Right? On the unannounced visits, we are in receipt of the different position papers, but maybe to start, maybe call on the AFP. Just to recap, the contention in the last committee meeting was with respect to unannounced visits refers to, well, it's defined here as visits that may be conducted at any time and without prior notice or authorization. And then they wanted to, I believe the AFP wanted to insert exceptions for, I won't detail exactly the wording, but the idea is for exceptional circumstances or exigencies, you know, that bar basically as an exception to the unannounced visits. I do understand the apprehension of certain groups to the effect that this would defeat the purpose of the inspection, which is supposed to be unannounced at any time, any place. There has to be a reasonable middle ground here, because you know, we do know that it's not always possible to do unannounced, unrestricted access at any time. You know, that is just my, you know, if there's an earthquake, for example, you know, you cannot do an inspection. Or if it's ravaged by storm, you know, or things, or like force majeure, which is a trending term nowadays, force majeure, right? It's hard to do an inspection. So I feel and I appeal to everybody to be reasonable, you know, to be reasonable. So with that, let me hear from the AFP. Do you have a copy of all the, just to verbalize, it's on the screen. The committee secretary has summarized the position, the respective positions of the different stakeholders. It's on the screen, but just to, so that to contextualize it, maybe hear from the AFP, just to summarize your proposed revisions to Section 3J.
Good morning, Mr. Chair. I'm Colonel Esquivias from the AFP Center for Law of Armed Conflict. Our proposal, Mr. Chair, is that, well, we agree that under the Constitution and under existing laws, the CHR can make unannounced visits and have unrestricted access. And now with the bill on the NPM, we propose that there should be exceptions on the conduct of unannounced visits. Looking at the screen, we propose that if the detention facility inside the military camp, and that military camp is on heightened alert or is on a red alert status because of force majeure or other grave situations, which can be, I think, enumerated in an IRR. This can constitute as an exception to the conduct of unannounced visits. And that a correlative can be included there, that as soon as the threat is downgraded or is lost, the conduct of the visit can continue.
Okay, maybe hear from TFDP. Can you please verbalize your position? It's actually there. It says amend definition of unannounced visits and unrestricted access to remove the possibility that such access is restricted under any circumstance in accordance with the broad and comprehensive NPM powers enshrined in the OPCAT. In other words, yan, fill in the blanks.
Good morning po, Kong. Regarding the raised by the representative from the AFP, first, sir, magkakaroon ito ng exception that would also magiging permission based, and who will determine that a certain facility is under red alert. So magkakaroon po ng opening that would prevent and the same time to defeat the very purpose ng NPM, which is yung immediacy, yung independence niya, and at the same time, sa surface ay reasonable. But sa operations, magkakaroon to ng permission base. Meaning, kung wala kaming, yung NPM ay magsisik pa ng permission to the AFP, o mag-request ng permission sa AFP, and they will claim that this facility, quote and unquote, is under red alert status.
Okay.
Yun po yung ano.
Okay, so you say, Mr. Briola, that it'll be permission-based, and I'm going to propound a question, actually, to both the AFP, and also, this is in response to, just to probe your insights. Is it going to be permission-based, or when they visit, they're going to be barred entry because of an existing red alert? You see, dalawa po yun eh. Yung permission is done in advance. But I agree, that defeats the purpose of unannounced. Then you therefore announce your visit. However, if you're barred entry because of an emergency situation, there is no advance notice, except that you are denied access because of an existing situation. Colonel Esquivas, what say you?
Sir, pwede naman po ma-address yung ganong issue. For example, we are now in the process of having a TOR with the CHR on the conduct of their unannounced visits.
Ano yung TOR? Just to spell out.
Terms of reference po,
Okay.
Mr. Chair, na we are in the process of discussions po so that we can have a TOR. Ang mangyayari po, kung meron pong kunyari may sakuna, biglang nagka-earthquake, for example, so automatic nag-heightened alert or red alert status, and they want to conduct a visit, ito po ay hindi matutuloy. Pero para po maiwasan yung mga ganong issue, magkakaroon na po ng agreement between the CHR or in this case, the NPM, na meron na pong agreement na yung, for example, merong regional office, kunyari lang po, ang NPM, at sila po ay gusto pumunta sa isang detention facility. So, meron pong i-designate na focal persons on the side of the NPM regional office and yung concerned officer po ng military camp para po may coordination na sila, may collaboration na they can conduct, that the NPM regional office can conduct an unannounced visit anytime because this will be covered by identification and mission order, mga ganung bagay po. So, for example po, nagkaroon po ng sakuna at dahil nga may focal person, sila po agad ay magko-coordinate, mag-uusap na ay hindi pwede ngayon if you're planning to conduct an unannounced visit, huwag ngayon. Pero as soon as the kung na yung threat and na yung operations, pwede kayong mag-conduct. So, hindi naman po permission-based ang tinutukoy doon. But the matter po of collaboration and coordination in the conduct po of the unannounced visit.
So basically, ang sinasabi niyo po, just para maunawaan ko, yung terms of reference does not apply to specific visits, but rather, magkakaroon sila ng agreement na to the effect that mauunang ipapaalam sa NPM na sa kasalukuyan mayroong red alert o emergency situation, kaya kung nagbabala kayo na bumisita, wag ngayon. Ganon.
Ganon po.
There's Mr. Briola, ganon po yung permission naman is visit specific. Mauunang malalaman ng for example ng detention facility or Bucor or whatever the place is na magkakaroon ng visit, tas doon pa lang sasabihin na may red alert at hindi pwede. Yeah, there's a difference. I don't know if you appreciate that, no? Would you like to respond, Mr. Briola?
Yes, Chairman. We recognize, sir, yung concerns of the AFP. But, una, sir, ano available remedy? For example, the NPM. Questioning the declaration of the AFP, declaring certain facility is under red alert. Unang-una, saan ang NPM makisik ng remedy? Who will, saan sila maaaring questioning yung ganong declaration ng AFP that this facility is under red alert? So, kasi kung sa definition, very broad, Chairman. So, meaning that it will prolong the delay ng NPM visit. So, in the very core principles ng NPM, yung immediacy ay nandidefeat. So, kung may ganong kasing definition.
Ang sinasabi nyo, natatakot kayo baka arbitrary. It is arbitrarily declared the existence of, how do you say that? Declare red alert, gano'n, di ba? It's arbitrarily declared red alert. So, turning back to Colonel Esquivas, ano ho yung mga pamantayan? Is that something that is defined by law, by rules? Itong existence of a red alert, if that in fact is the exception that you want to insert, red alert or emergency situation?
Ang term po na ina-espouse po namin is heightened alert status. So it can be a red alert or a blue alert, depende po sa yung gravity ng situation. Kagaya po kung meron pong bagyo, no? Kasi mga naranasan natin, may bagyo or may civil unrest, may earthquake, mga ganung bagay po. Pwede pong maging reason yun na yung kampo po mag-lockdown or there will be conduct of operations. Kaya maganda po yung mga nire-raise po nilang mga issue, maganda po mailagay yon sa IRR para ho mas klaro. And if they feel na kailangan po merong remedy, that they can, kung saan po sila pupunta, pwede rin po siguro na gano'n. Kasi sa amin po, ang lang naman namin is, kung lalo na yung safety and security ng team na pupunta, paano po kung merong yung safety and security nila is an issue. So, dapat po talaga na wag matuloy yung unannounced visit.
Ang parang sinasabi ni Colonel Esquivas, Mr. Briola, is that maraming pwedeng gawin sa terms of reference na hindi, that it won't be tantamount to a permission-based visit. And also, sinasabi niya, I'm just paraphrasing, na maaaring lagyan ng guardrails in terms of reference para hindi umabot sa punto na aabusuhin ito na gagamitin arbitrarily ng AFP, halimbawa. Kasi yun ang kinakatakutan eh. Papaano kunyari, ginawa na lang, ilang kulay po ba yung alert? May red, may blue, ano pang kulay? Ha?
May white alert din po, no? Pero
Mahina po yung white alert.
yun medyo po yun, tawag nun, normal po. Pero kung blue alert po, minsan po yung mga tropa po are required to come back to the facility.
Baka naman ho, maging from blue, maging red alert, tapos balik ng blue. Hindi na matatapos, hindi na makakabisita.
Pwede pong mangyaring ganun eh. Like, kunyari po, nagkaroon ng bagyo, landslide. So, all available personnel in a particular AFP camp are required to help in the clearing, in the rescue, pati rehabilitation. Pero hindi naman po forever yun.
Hindi. And also, I'm just throwing out ideas, Mr. Briola. The terms of reference could also, aside from the situation, or the alert level for a particular situation, could also carve out certain locations. Like only in the affected area, something that would limit it. Pwedeng ganon. I'm just throwing it out there to see if there is room for consensus. Kasi pag walang consensus, kami po mamimili. The whole point of this committee meeting is not really to arrive at a consensus, but to inform the judgment and discretion of Congress. Because in the end, we will have to issue a verdict, our call on a particular matter. Pag if a consensus is impossible, but maybe hear from ASEC Pereira's first.
Although the independence of the NPM is essential, I believe that there must be a joint protocol. That joint protocol must be included in this in the bill. The requiring the CHR to establish a joint implementing framework, parang sa coordination mechanism that will answer all of these things. It can be in a memorandum of agreement between the CHR and the Bucor regarding defining the processes on the entry, on the visit, on the conduct of inspection, everything like that. It should be included in that joint protocol that must be institutionalized in this bill, sir.
Ang tingin ko po, ASEC Pereira's, maybe perhaps you will agree, it doesn't have to be detailed.
Yes,
There
sir.
has to be a reference, if we're going to head in that direction, a reference to the joint framework, subject to, it has to be fleshed out further in the implementation of this bill of the law when it becomes a law. Parang ano lang, so that there's not, to avoid an undue delegation of legislative powers, Congress merely has to provide the guardrails, the criteria. For example, that it should not be arbitrary, not of long duration, that it has to be it has to be localized only to the affected areas. These are the examples of criteria, and that it will not be tantamount to a permission. It's not permission based. Kasi it defeats the purpose of being unannounced. Ang sinasabi ko po, kasi kung di detalye natin dito lahat yan, ay hindi tayo matatapos. It's okay to delegate that responsibility to the implementing agency because they know the conditions on the ground. The role of Congress is merely to provide what are the metes and bounds of the delegated authority. Pwede nyo gawin yan, pero huwag mong gagawin of unlimited duration. Hindi nyo pwedeng ganyan. O kailangan subject to review by ganyan. You could do it that way. Because effectively, if it is abused, I appreciate the view of Mr. Briola. They cannot do unannounced visits anymore. If there are only 365 days in a year, if they keep on changing the situation, and not just the alert level status, but other exigencies and all of that, ay pag dumaan ng panahon ng bagyo, alam niyo naman ang karanasan natin. Doon po sa amin sa Bataan, pag bagyo, parang forever. Di ba? Yun ang parang forever talaga. Hindi makakabisita at all. Di ba? Yun po ang ayaw natin mangyari. So, if we're going to have a joint framework or terms of reference, the metes and bounds of the terms of reference need to be defined here. But we are not going to say what it is. Yun po ang, on the other hand, if we just say joint reference, subject to the joint reference as maybe reached or agreed upon, baka sabihin naman, that's an undue delegation of legislative power because you did not provide the criteria. Di ba? Pero, yung kung sabi ni Mr. Briola, magiging permission-based. O sabihin natin halimbawa, should not be tantamount to obtaining a permission to visit. Number one. Number two, the restriction springing from the red alert status should be localized to the only affected area. Oh. Kunyari, in the case of force majeure, kung saan nagiba, kunyari, malaki yung facility, may isang lugar na nasira, o binaha, o di wag doon tayo sa iba. Doon lang. That it is of limited duration only. These are possible, criteria that will basically, that the implementing agencies need to comply with when they draft the joint framework. Yun po ang sinasabi ko. Pero if we are gonna detail everything here, wala po. Wala po tayong, but perhaps, Director Fajardo, what is your experience here? Kasi sanay, yung karanasan ng OPCAT.
Okay, good morning po, sir. I-clarify ko po, sir, na magkaiba po kasi unannounced saka unrestricted. We're actually medyo na-mix po natin ng konti. Yung tungkol po sa unannounced, if we will be crafting a legislation and we will expect that it be compliant with the OPCAT, I will frown upon any restrictions with regard to the unannounced aspect. Kasi yung unannounced aspect, para lang po maging malinaw, i-liken or i-analogize ko siya sa leaves. Tayo po kasi may sick leaves. Yung unannounced visit, hindi required mag-ask for permission. It's just the act of the NPM. Bale, hindi required ng isang NPM of a state to ask for, to submit notices for a visit. So they can attempt to visit. They're not required to give or ask for permission or a notice. So it's a sick leave. So pwede kayong mag-leave. Kaya lang, pagdating dun sa access nila, that part is where we can already discuss if there's restrictions to the access. It's not just within the facility, it could also be with regard to whom they want to talk to, as well as the documents that they want to access. Yun unannounced, I think, kasi, sir, there are already certain laws that we've already passed that is already using the term unannounced.
Correct.
That's the enforced disappearance as well as the torture. So, yun requirement lang from the body to issue a notice or to submit a notice. Hindi siya, sir,
No, that's permission. That's not, it defeats the purpose of
yes,
the visit.
it might not be OPCAT compliant if there's.
I agree. I believe, now that you mentioned that, I believe I mentioned that in the last meeting, where I said, we might be barking up the wrong tree. We are talking about unannounced visit, but actually, what we want to, for lack of a better term, what we want to regulate is the access. Ito po yung binanggit mo, talagang makalimutin lang po ako tumatanda. Kaya hindi ko maalala. But I did mention that, now that you mentioned it. So, turning to Colonel Esquivas, if you share my view and also the views of Director Fajardo, that maybe it's better to talk about access. It's not the unannounced visit. Because tama din po yung sinabi niya at sinabi ni Mr. Briola, this is the whole point of the NPM. It's the unannounced visit. And Director Fajardo, you wish to say something?
Sir, tapos sir, taga-executive branch naman po kami. From a bureaucratic perspective kasi, medyo, I would say, it adds on to the bureaucracy or the inefficiencies kasi magkakailanganin mo ng desk to receive the notice that there's going to be a visit, and you need to process the visit, so it's an add-on to a problem.
No, I
Parang
think
it's an
I think we're
add-on.
not. Nobody is saying that. I don't think Colonel Esquivas is also, he is asking for prior notice of a visit. It's not that. But I hope, Colonel Esquivas, this is more an issue of unrestricted access than unannounced visit. Do you agree?
Yes, sir.
Okay.
Ang ano ko lang, sir, kasi kung pupunta na sila, tapos sinabi sa kanila, hindi kayo pwedeng mag-conduct ng visit dahil nga red alert. Yun po yung
That
iniisip
would
namin,
be,
sir.
you are in effect denying access And that's why in the example I gave earlier, diba, there was no prior notice, no permission sought. They just visited. It is unannounced, but they're denied access. Then they're denied access. That goes to unrestricted access, right? So with that, we will adopt unannounced visit as defined here, because this is the wrong tree. We should be focusing and talking about unrestricted access. Okay po ba yun? Oh,
Mr. Chair.
I would like to
Congressman
say
Pimentel.
that,
Yeah,
good
floor.
morning. Good morning sa lahat. I have been in the Philippine Army assigned sa ISG. Now, when I was governor, may phobia ko dyan sa unannounced visit. First, yung nangyari sa Surigao. Naka-uniform yung mga pulis. Pumasok sa provincial jail. Yung pala, ilalabas nila yung 6 na Sparrow na nahuli namin. Dinisalmahan. Second, may mga naka-uniform na pulis, NBI, 6 o'clock in the morning, hinuli yung mayor, si Jimmy Luna ng Lingig. Dinala sa munisipyo, pinapol in ang pulis. Yung pala, didisarmahan lang, mga NPA. So, dapat meron tayong safeguard sa unannounced visit. Tapos may mga call sign at saka bahala ang military dyan sa pag-ano ng nila, security, kasi national security yan eh. Yun lang yung akin, kasi delikado yung unannounced visit, dapat may safeguard talaga. Hindi pupunta, general ako, inspection, pull in, yung pala, disarmahan. So, tapos nangyari din nung 89, nung nasa ISG kami, pinasok kami ng Scout Ranger. Kasi inspeksyon, ikodita pala, hindi namin pinapasok. So, yun lang yung akin, lagyan lang natin ng safeguard.
Thank you, Congressman Pimentel.
Thank you.
I think, with respect to you, the AFP and also Director Fardo and also TFDP, Task Force Detention. Because if we insert or include safeguards here with respect to unannounced, it's pointless to talk about this law. I believe that's the whole point of this of the NPM is that it has to be unannounced. But to address your concerns, and the concerns are also raised by Colonel Esquivas, maybe it is more, we should focus more on access and not the visit, not unannounced visit, but yung unrestricted access. I think that, kasi yun lang yung concern eh. I think it's, when you look at the two terms, unannounced visit and unrestricted access, it's easy to confuse the two. But actually, they're different. Now, one is unannounced. Because the whole point of the NPM is preventive eh. So they can go there. Opo.
Mr. Chair, kung unannounced visit, dapat may dala silang papeles para ma-validate, ma-confirm. Kahit na unannounced, pero dapat ipakita nila doon sa battalion commander o yung kampo na papasukin nila o unannounced, pero you could verify as and validate para maiwasan natin yung mga peke.
Opo. Director Fajardo.
Sir,
And then, Mr. Nasarias of Balay Rehabilitation Center.
to address the concern of Congressman Pimentel po, sir. The Commission on Human Rights po, sir, already exercises said mandate of visiting unannounced. They do so, sir, in two instances. One is their regular visits that would sometimes be unannounced. They would give notices. And in the second instance is when there's a reported torture. And of course, sir, hindi po siya announced. But the law itself is very strict with the requirement of identification, sir. And the safeguards for that is that yun CHR may identification sila, and they're not allowed to just go in na hindi properly identified as CHR. And familiar po ako dun sa incident na sinabi niyo, sir. Thank you.
Yun nga ang sinasabi ko. Unannounced na pero dapat magpakita ng credential that can be verified and validated and confirmed sa agency. Kasi ang dami ng experience ko dyan sa Surigao. Thank you.
Thank you, Congressman Pino. That was a point well taken, you know, and also maybe hear from Mr. Anasarias.
Maraming salamat po and good morning. Well, sa pagkakaintindi ko ay insofar as the NPM is concerned, klaro po yung mandate nila to undertake preventive visits. At yung composition nila ay mga civilian yan, mga experts in different fields of competencies, medicine, psychology, social work, and etc. And kung mako-constitute na itong NPM, naturally mayroon silang legal personality na accorded by the law, and in due identities nila would also be established at that time. Kaya yung concern na na-raise ni Congressman, with due respect, if I understand it, mukhang sasagutin naman siya ng batas. Pero ang naintindihan ko, if I understand it correctly, tama naman yung concern kung ang pinag-uusapan natin ang bumibisita ay security forces or people or groups claiming to be part of the security forces. Kasi yung mga instances na binanggit po ni Sir ay parang mga ganon, no? May pumunta na ganitong klaseng military or nagpakilalang ganito, then they spring out yung mga detainees, which I think ay senaryo na hindi yung kino-contemplate under this law at mukhang walang ganong senaryo na pwedeng umusbong dahil nga dun sa, again, sa mandate, identity, at saka yung scope ng work mismo ng mga taong magko-compose ng NPM.
But that's, as Director Fard has mentioned, there will be proper identification of the NPM, no? Colonel Esquivas, and then after that, I'd like to move on to the next section. We'll preserve the wording as is, and we'll talk about unrestricted access. Go ahead.
Short lang, sir. Yung po yung nabanggit ko kanina, sir, na pwede pong ilagay sa IRR na kung magkukonduct po ng unannounced visit yung NPM team, they shall be duly identified, may uniform, and covered by a mission order. Para limited lang po talaga yung pupunta sa sa place of deprivation of liberty. Kaya lang po ako yung exceptions dahil nga po doon sa powers and functions ng NPM nakalagay po doon to conduct regular and unannounced visits to places of deprivation of liberty. Kaya yun po yung gusto na malagyan sana ng exceptions, and kung wala na yung threat, dapat makonduct na yung unannounced visit. Yes, sir.
Itong unannounced visit is just temporal in nature. It's just focusing on the time and not the places. So, I guess, we'll keep it unannounced. Diba? We'll keep it unannounced and let's move on to the next. We'll preserve.
Yes, sir.
Ano ba to? 3J? 3J. We will adopt this as is. And then we'll talk about unrestricted access. And also, ComSec, when we get to the portion of the implementing rules, maybe we can make reference to the terms of reference or joint framework, and talk and address proper identification and all that. Doon natin ilalagay sa implementing rules. But now, let's move on to... Kailangan ko ba pumukpok? Hindi. Huwag na. Kailangan daw pumukpok. So, Article 3J is adopted as... ano ba to? RA? House Bill... The substitute bill, the NPM working draft. Is that the reference? No. So, Section 3J of the NPM working draft is adopted. Moving on to the next section or next letter. Unrestricted access refers to free access to the following unless specifically prohibited by court. So it goes on to enumerate 7. So it's on the screen. Pakita lang po natin yung... Hindi na ho ba mapapaganda yung contrast niyan? Parang namumutla yung mga letra. Oh. Okay lang. So, all persons deprived of liberty with the opportunity to have the private interviews with them without witnesses, either personally or with a translator, if deemed necessary. All custodial personnel involved in or relevant to the treatment of persons deprived of liberty, any other person involved in relevant to the treatment of persons deprived of liberty, any other person or source that the MPM believes to have relevant information, all information concerning the number of persons deprived of liberty in places of deprivation of liberty, as well as the number of such places, location, all information referring to the treatment and conditions of persons deprived of liberty, all places deprived of liberty and their installation of facilities. Understated as includes the liberty on the part of the MPM to choose the places that it may want to visit and the person that it may wish to interview. O, yan na. When you read that, I think you will agree. I'm trying to, this is mind conditioning. I think you would agree, mind conditioning, that it's okay. The listing is okay. Now, but then, what will throw a wrench in the discussion, or is the earlier discussion, is that the exceptions that are sought. So maybe hear from the AFP. Ito sinabi nyo, okay, if I were to paraphrase the concern you raised earlier and read your comment here, you want to, you want an exception grounded on two things. Number one is yung red alert, emergency situation. The second one, you said here, set parameters to be considered by, since the military facilities may contain areas that are off limits, then you're also looking at the location. So it's a combination of like, what is the situation and the location. But you could elaborate further if I am misstating or understating your concern.
Thank you, Mr. Chair. Yung nga po yung kung may red alert status, heightened alert status. So, dito lang po tinutukoy po namin kasi sa isang in a camp, no, there may or they may not be a detention facility. So consider this the NPM, so they have unrestricted access to the detention facility. So that would mean that not all parts of the camp can be inspected or visited by the NPM because of national security considerations, sir. Yeah, we understand that if ever the NPM team would want to inspect other areas of the camp, not necessarily the detention facility, this should be based on evidence and not on mere suspicion, sir. Kasi nga po, to give effect to the NPM, we will allow that they can, following the unnecessary access on information, on the PDL, on the records, and the like, yung po yung namin na, based on number 7 po kasi, nakalagay din po doon na the NPM may choose the places that it may want to visit. So dapat po meron din pong doon na hindi naman haphazard or without legal basis or without evidence na buong kampo ang titignan nila. Dapat yung detention facility lang po.
Colonel Esquivas, but if you put yourself in the shoes of the NPM, you put yourself in the shoes of the NPM, you know where they're coming from.
Yes.
Nakikita nyo? Because you could basically protect from inspection places, right, that are not ordinarily used as detention facilities. not ordinarily used as detention facilities. Eh, kunyari, dinitain dun sa opisina. Oh. Di ba? So, no, you can't visit that because it's the office, it's the head office of the general. But there's a secret quarter there, or secret room, for example, where somebody is detained. You know, it's not ordinary use for detention, but if you insert that, then you are basically protecting these places from inspection on the guise that these are not detention facilities. Nakikita niyo po yung sinasabi ko. So, perhaps, may we hear from, is there anyone, I'd like to hear, yung ano I think what will inform the discussion here is yung experience, you know, of other countries, how have they done this, how have they addressed these issues. Because, let's face it, merong cynicism Merong cynicism. There's a bit of distrust, and not saying in itself that it's bad, you know, and that's the whole point of why we're legislating it, is to address this, distrust or cynicism. Okay?
Ms. Paulson is here from UN.
Yes. Ms. Paulson, would you like to weigh in?
Yes, I think, no, I thank you for that. I think it's a tricky one, and indeed, as you say, this is a discussion that comes up in every parliament or in every country where a national preventive mechanism is being discussed. This is really nothing new or surprising, because there is this tension between, you know, security and confidentiality, and then open access and transparency that we have to balance somehow in the legislation in a way that that the NPM remains credible, but also that there is no threat to national security, right? So this is sort of the balancing act we're trying to figure out. And it will differ in every country depending on the context, of course. That's where you come in. But overall, there is a provision in the Article 14.2 of OPCAT with this wording that objection to a visit, so again, it's about the restriction, may be made only on urgent and compelling grounds of national defense, public safety, natural disasters, exactly as we spoke about, or serious disorder in the place to be visited, that temporarily prevent the carrying out of such a visit. So it has to be temporary, and it has to be a decision on an individual case basis. But of course, a restriction can be made if you think there is really, you know, some compelling reason for national security. I think, though, that the important thing to keep in mind, too, is that this is, you know, hopefully the number of people who will be part of this national preventive mechanism will be vetted and trained and employed. It's not arbitrary people you are letting in. It should be experts. So probably that could also be taken into account, that it's not just anyone who can come, and, you know, the access, you know, we're only talking about a specific subset of people who perhaps in their terms of reference would also have confidentiality clauses if there is something like this. So these are the kinds of things we talk about internationally when it comes to restrictions. So I think putting into the text of the law that article and those restrictions is okay, and you can do that. But it has to be places where persons can reasonably be believed to be detained, not just those authorized, you know, places, because we know everywhere that people do tend to get detained in various places, and as someone was pointing out yesterday, even places of transit can be places of detention for a certain period, right? So So it should be a broad interpretation of where inspections can take place as far as is possible.
Ms. Paulson, other than this section 14, is there any other text relevant to this discussion?
No, I think this is the
That's it.
main one.
Section
The
14.
other place you can look is in general comment 1 on the optional protocol, which is exactly about this issue of access and restrictions.
Do you have the text of that general comment 1 you mentioned?
Yes, I can.
Can you? Well, we would like to flash it for everybody's consumption and enlightenment. But that is really helpful, and I was informed. I am informed that that particular language is not in this bill, so that even if we, with the insertion, even if we insert that language, it's still going to be OPCAT compliant. Oh, Director Fardo.
Sir, I'm going to, I'll be treading softly on this, sir. I mentioned that during our last meeting, that kung kinakailangan talaga, sir, na magkaroon ng restriction, I will recommend na yung restriction be coming from the
Section.
OPCAT itself. However, that OPCAT provision, which Ms. Sinye had reminded during the last meeting, applies to the Subcommittee on the Prevention of Torture, which is the UN body, the global body, which is the NPM, the global NPM. So, but sir, you had mentioned earlier of the practices of other states. So we did do that study, and sir, normally, sir, hindi talaga nilalagyan ng restriction. There was one state that placed it on their text, the restriction. What they did was, they took this, kinote nila yan, sir, yun sa anti-torture law ng state na yon, kinote nila for SPT visits. They were already considering that they will be visited by the SPT. Thus, yun restriction, inadopt nila. Subcommittee on the Prevention of Torture, that is the global body, the global NPM, the version.
So it's for the SPD only.
Yes, that's the UN body, sir.
Yes.
So ngayon, sir, although I say that it's a restriction within a UN document, I will not be as bold as Ms. Sinye to say that it's going to be OPCAT compliant. Kasi, sir, we're going to make a law, and of course, at the end of the day, we want that to be OPCAT compliant. I'll recognize the limitation, sir. And actually, sir, sa totoo lang, hindi naman kailangan ilagay in a text. Talaga naman exception to the rule of practically exercising a lot of rights. Like, for example, may ibang rights talaga na nalilimit by national security talaga yun minsan. Ayun lang, sir, yun ano ko, sir, about it. And yun pangalawa, sir, is we were discussing about the unrestricted aspect. Ngayon, sir, yun OPCAT itself, since it's already on the board, sir, yun OPCAT itself, with regard to visits, doesn't use the term unrestricted. So we could call it from the actual provisions of the OPCAT in Article 20. It doesn't use unrestricted. It's a friendlier version, but it's focused on access. So, ayan po yun, yun NPM, sir. Wala po dyan wording na unrestricted
Referring
So
to
that's actually the mandate of the NPM. They're enumerating the mandate of the NPM. It doesn't use the term unrestricted, sir.
Can you scroll down, please, Article 20? Okay. Are you saying that, what if we adopt this instead of this one?
Purposes of consensus, sir. Because at the end of the day, we prefer it to be OPCAT compliant.
Yes,
We could
that's the whole
just
point
make,
of this.
we could just make it a more efficient yung construction, sir, it's a bit hindi siya efficient masyado, sir, yun.
It says access to all information, okay? Access to all information referring treatment. Access to all place detention and installation of facilities. Oh, opportunity to have private interviews. Ito, would this be would this be amenable to? Is the AFP amenable to that? Pwede ho natin palitin para medyo makita natin yung full text ng article. Makarami tayo. Ay, sobrang liit naman yan. Masakit sa mata. Ayan. That is the OPCAT wording, no?
This Article 20 refers to the SPT, no? Di po, to the NPM, no? So yung nga po, Mr. Chair, reservation namin na the liberty to choose the places they want to visit and the persons they want to interview. Kasi nga po yung nabanggit kanina na based on national defense, iba po ang national security sa human security. So,
Pero ang problema po, John, Colonel Esquiva, sorry to cut you off, is that yun nga eh, and I think Ms. Paulson raised this earlier, or who was it? That places that are not traditionally detention facilities have been used as detention facilities, precisely because it's it's not suspicious. It's not a suspicious place. Yun po ang concern eh. So, but Director Fajardo.
Sir, yung pag-construct po ng item ES, yung liberty of choice lang naman yan, sir. So, the NPM, I think, be allowed the liberty of choice.
Right.
Ngayon, what Colonel Esquivia says, ini-express niya is that since the NPM's mandate is persons deprived of liberty as well as places of detention, regardless if it's temporary or ad hoc in nature, then maybe we could just reconstruct it to conform to his
Letter E. We can revise
in a
letter E.
manner that it considers the term place of detention as well as person deprived of liberty.
Okay. Since you brought it up, can you propose? No, really. Look, like I really appreciate the insight of Ms. Paulson because she recognized the problem and she proposed a solution. If we're going to, comment, if you're going to share your insight, I would appreciate that as well. State your concern and how do you propose to address it? Not just concern, but also the concerns of other parties. That way, it's like we are not, we are reconciling our insights. It becomes reconciliatory instead of like adversarial, and it becomes a zero-sum game. Diba? +1, -1. Gusto ko, ayoko ng ganun. Gusto ko, meron tayong pinupuntahan. Teka, ready ka na ba mag-propose? Ready na siya mag-propose. Teka, hold your comment first, Director Fajardo, go ahead.
Sure. The liberty to choose the place of detention they want in accordance with the sections that we've already covered during the last meeting. We already defined the place of detention.
Yes.
And then they want to visit, and the persons deprived of liberty, they want to interview in accordance with the sections, which is in the previous sections that we've
yun.
defined.
Maganda yun. Wow. That's the major concession and significant concurrence. Miss Sevilla.
Salamat po. Pero kasi kagaya rin po nung nakasaad dun sa number 2 at number 3.
Ng ano po? Dito?
Apo.
Dito po
Number
sa
7 po yung pinag-uusapan natin.
number 7. Okay, okay.
Yung merong yun po kasing iminungkahi ni Sir Tito ay persons deprived of liberty, pero under the ay hindi lang persons deprived of liberty ang maaaring kapanayamin po.
Didagdag natin. Pwede naman yun, di ba?
Ito naman po, sir. So
Oh.
we can cite the previous sections for the definition already.
Yes, we shouldn't interpret we should interpret provisions here contextually in the broader context of the entire bill. That's how it is. And he's mentioned yung places previously defined, persons that of interest, like whether PDLs or anyone else, previously defined. So with that, if we revise, and we already have the concurrence of the AFP, anong item yun? Number, yung kanina yung re-revise? Hindi yan, yung isa.
Yung Article 20 ng OPCAT.
Yes. Yan ang re-revise. Okay, work on that. Work on that. State it one more time, Director Fajardo.
The liberty to choose the place of detention they want to visit, tapos sir yung section in accordance with sections that we've previously agreed
As
upon.
previously, as
In the
accordance
section,
with-
sir.
Okay.
And the persons deprived of liberty, they want to interview the persons deprived of liberty in the previous sections that we've all agreed upon, sir. Then sa definition of
The
person
concern of
deprived.
Ms. Sevilla is that they may want to interview not just persons deprived of liberty, but other persons. Nasaan po?
Yes, Mr. Chair, it's in the enumeration already. If we look at the unrestricted access and the
Okay.
enumeration 1 to 7, 1 refers to persons deprived of liberty, 2 refers to custodial personnel, 3
Okay.
refers to other
Okay.
persons involved in or relevant to the treatment, and so on and so forth.
hindi, we will not mention persons deprived of liberty. Persons, they wish, where's that? Nasaan na yun? Biglang
They wish
nawala.
to interview,
That they want to interview as enumerated in,
as enumerated above.
as enumerated yes, so alam na ni Comsec yun. So we will, are there other insights, objections? I think that takes care of our concerns.
Yes, sir.
Thank you for the suggestions. So we are adopting section 3K. No, actually, no. 3K as revised. Okay, as revised. Alam niyo na. Okay.
Mr. Chair.
Congressman
Can I have the
Pimentel.
floor? Thank you, Mr. Chair. As Chairman of Strategic Intelligence, we are no strangers to the security intricacies. We have to keep in mind existing the geopolitical realities. We have adversaries, non-state and state, unrestricted access to all places in military installation would be counterintuitive. We have an existing insurgency and terror issue, plus adversarial countries. In fact, we have a pending anti-espionage measures to secure our civil and military installations. We are a country not without enemies. Unrestricted access to all places would endanger our men and women as well as national security. May I just remind everybody.
Maraming salamat, Congressman Pimentel. To address your concerns, I think by referencing the previous sections, the previous sections actually provide the restrictions. And also, it limits it already. Kasi na-enumerate na ho previously. At saka, what we made clear here is that we deleted the word unrestricted in the draft and instead opted for the text from OPCAT. No? Yun po. So, with that, we are... Mr. Anasarios.
Thank you so much, sir. May I seek some clarification?
Opo.
Opo, this pertains to number 6 of the same section.
6.
Yes, and it says that it refers to access to information regarding, referring to the treatment and conditions of persons deprived of liberty. Ang clarification ko po, would this set of information include, for example, mga CCTV footages or other electronic information?
Okay, before anyone answers your question, just to ComSec. So what we are doing is we are adopting the OPCAT language and then revising letter E. Letter E. So just want to be clear. Huh? Okay. So the concern is what particular types of information? CCTV?
Yeah, for example, yes sir, and mga electronic detention records, other custodial documentation. Pumasok lang din sa isip namin yan dahil alam naman natin in this day and age, information are also stored electronically.
Yes.
And information are captured also in CCTV images. So.
Before we answer your question, can you please flash the OPCAT language to see that there is a comparable language? Access to all information referring to the treatment of those as well as the conditions. Ayan po, letter B. Tama, yan po yung tinutukoy nyo. All information. Okay. My plain reading of that, plain reading, information could be digital or it could be physical. It's, virtual or physical. So my take on that is that it covers CCTV.
Thank you, Mr. Chair. So long as yun ang ating
Kasi
shared
all, it
understanding,
doesn't
then
qualify.
Okay lang. Thank you so much.
Okay. The only limitation there is privacy laws. But we don't have to state it there because it's protected by law. Personal information or sensitive personal information, sensitive information or personal information is protected by data privacy. You know? So okay na tayo dyan? Asik Pereras.
We are under the Department of Justice to exercise power to amend and review decisions of the Bureau. And if it involved, if the person involved is a high profile or high risk PDL, it must be approved by the Secretary of Justice. What will happen to this now? Are we going to disregard the approval of the Secretary of Justice if it involves high risk or high profile or members of the violent extremist offenders?
Yung tanong po niya ni Mr. Nasarias is CCTV. No? Ano pa yung isa? CCTV lang, ba?
Kung meron din po mga iba pang mga digital devices na mag-store ng
Malamang
information.
CCTV lang yan.
I'm just wondering kung...
Yung tanong niyo ba, Mr. Pereras, are you talking about CCTVs?
No, sir. It involves yung interviews. Letter to conduct interviews.
Can you flash the OPCAT that has been that we are adopting?
The letter
Alasan?
B, sir, the opportunity to have private interviews.
Access to all information referring to those persons as well as their conditions of detention. The opportunity, letter D, sabi niyo
Letter
D.
D, letter D.
Akala ko B.
D.
The opportunity to have private interviews with persons deprived of liberty without witnesses, either personally or with a translator if necessary, as well as any other person who the National Preventive Mechanism believes may supply relevant information. What is the concern there? Is it the first part or the second one? Yung anyone?
Private interviews with PDL, sir.
Bakit po? What is the
Who
concern?
are either high risk or high profile or violent extremist offenders. Because in our regulations, sir, we need to secure the approval of the Secretary of Justice. That's one of the limitations, sir.
That is a rule?
Yes, sir.
Then the rule will submit to the law. because the law will supersede, takes precedence over regulations. And if we change this, it's not OPCAT compliant, correct?
Kaya nga sir, kaya
This goes to the heart of the bill.
nga sir, there is a need to have a joint protocol regarding this. Kasi iba naman sa EIP, sa Bucor, iba sa PNP, iba rin. Kaya iba-iba sir eh.
Mr. Asik Pereiras, you appreciate the spirit of this. Hindi sila magsasalita kung merong yung witnesses. Yun po yung spirit doon, tama?
Yes sir, without
There's no freedom and no confidence in opening up. They won't open up if there's somebody watching them.
kaya nga sir, it will be defined on the joint protocol sir eh.
I appreciate your point. I get your point. But I'm asking, in and of itself, interviewing a PDL, ba't nawawala? Without witnesses, what is inherently objectionable about that? Meron ho bang, is there anything inherently objectionable about interviewing PDLs without witnesses? It doesn't prevent, the NPM or from interviewing the detention officers. Pero sinasabi, pag kinausap mo yung PDL, sila lang. Parang mediation. In a mediation, I talk to one party without the presence of the other party. And then I talk to the other party without the presence of the other party. And then we talk together.
But there must be consent sir sa interview na PDL.
Okay. Is this, can be heard on Dr. Fardo? Sec Pereira says that there has to be consent of the PDL. I would imagine that the PDL would have to consent because you cannot extract the information from him, by force. It has to be voluntary. Tama? Okay. Tama naman, voluntary naman po. This is merely saying that they may have private interviews with persons deprived of liberty precisely to get to the bottom of things or to extract the truth. Diba? Which is, unfortunately, when you have other witnesses, they may not open up. Yun lang po naman yun eh. Now, if you're saying, you should get the consent first of higher authority, it defeats the purpose of this. If you read the sentence, there's nothing inherently wrong with that. They want to interview persons deprived of liberty without witnesses. What's wrong with that? May masama po ba ron?
But sir, on the part of the Bucor, we need to secure the approval of our, because we are under the supervision of the Department of Justice.
You cannot interpose a regulation to defeat a congressional mandate.
That is why I'm proposing, sir, earlier to have a joint protocol or implementing protocol between CHR and Bucor, defining all of these things, the processes.
Such as in this particular instance, what particular definitions would you introduce in the implementing rules? For example, can you particularize, what implementing rules would you adopt with respect to privately interviewing PDLs without witnesses? Sige. Or maybe, since we, that's something that needs to be addressed in the implementing rules later on. Hindi naman sinasabi natin, wag natin pag-usapan eh. But in itself, there is nothing objectionable to this. You're not proposing, Asik Pereira, that we delete without witnesses. You're not proposing that. You're not proposing that they cannot privately interview the PDLs. So, if you're not objecting to either, then it's okay. Tama. And then, yung sa implementing rules, hindi naman natin, let them figure it out later on. Meron man implementing IRR clause tayo, di ba? Oh. Doon na lang po. So, gusto niyo mo talaga magsalita? Ha? O okay na. Baka umuga yung bangka. Tumaob tayo dito. Because,
I understand po yung recognize yung concerns po ng DOJ, but yun po yung the very principles ng NPM law, yung trust building. Trust building between and among stakeholders at constructive
yun nga po
dialogue.
sinabi ko eh. That's what I said. You cannot win the confidence and trust of the PDL. They won't open up if there's somebody else in the room. For expediency lang po, ano? I'm not gagging you from stopping you from commenting. But if you're just gonna say what I'm saying, please, in the interest of time, let's not comment anymore. Kasi nasabi ko na po, we want to move things eh. Di ba? Okay. Now, if you disagree, or you have a different viewpoint, please feel free to take the microphone. Okay? Okay po tayo. So, are there other insights? With DOJ? Saan magsasabi natin DOJ? DOJ has a comment on paragraph 4, but that has been overtaken by the OPCAT. Kasi inadapt na natin COMSEC yung OPCAT eh. So yung comment nila has already been addressed, right? Otherwise, they would have raised their hand to speak. Okay. So other comments? There being none? Okay, we are adopting... Okay, ano ba to? Section 3, paragraph K, as revised. In particular, basically adopting the OPCAT language, revising letter E thereof. Okay. Okay na tayo. Section 4 na tayo. Papalitan ko na ba ito? Hindi pa. Okay ba tayo? The next one. Section 4 is on the National Preventive Mechanism. The text of which appears on the screen. And we have received comments from the following: AFP, DSWD, TFDP, Philippine Alliance of Human Rights Advocates, Balay Rehabilitation Center. AFP says, add the words committee or commission after National Preventive Mechanism to express the NPM Commission is entirely separate from. The CHR. Tanong ko lang ho yung AFP. Gusto nyo po National Preventive Mechanism Committee or Commission ang reference to express that the NPM Commission or Committee is entirely separate from the CHR. But then in the second sentence of Section 4, it says the NPM shall be a separate but attached agency. So it makes it clear that it's going to be separate. Are you still insisting, or do you feel strongly about inserting committee or commission still, notwithstanding the second sentence?
Yes, sir. Based on the bills filed by Representative Rodriguez, it says that it will be a commission, sir. Para sir, klaro na NPM commission, not the NPM as a mechanism.
Okay.
Para klaro, sir.
Parang personifying it, you want to personify it, so it has to be like a noun. Parang mechanism goes to like the mode.
Yes, sir.
Or the method.
Tapos sir, yung sa naman, that the NPM is independent from the CHR. Kasi sir, under the anti-torture law, so anti-enforced appearance law, sir, ang CHR has the mandate. So para rin, sir, mahirap, tawag nun, dito sir, NPM is different from CHR. Ganun,
Oh,
sir,
but it says,
lalabas.
well, a couple of things. One, it says in the second sentence, it's separate but attached to the agency. The third sentence says it shall function separately, independently.
Yes, sir. So,
So,
attached to the CHR for budgetary purposes, sir.
nakalagay po yan. It's there. Second sentence. So, ang sinasabi ko lang, your proposed revision, in your proposed revision, you just want to use the word commission. Yun lang,
Yes, sir. Yes, sir.
Ms. Sevilla.
Ang suggestion ko po ay committee instead of commission. Parang medyo awkward po na may commission na naka-attach sa isa pang commission. And sa ibang countries po, committee rin yung tawag nila.
Ginagamit nila, committee.
Better
Okay lang po
idea,
ba
sir.
yun? Okay lang po ba yun? So, if there are no objections, we will adopt that suggestion. Okay, so we're adopting committee. COMSEC, kindly do a universal revision change. Yeah. Thank you. And then DSW says NPM must be expressly defined as an attached agency of CHR. Is the DSWD here? Ma'am, di ho ba nakalagay sa second sentence yun?
Yes po, but it's leaving ambiguity as to whether it will function po as a council, commission, or office po. So we would like for it to be clarified po.
Attached agency. So basically you want to, you're asking what is an attached agency? Correct? Yun ba yung tanong mo? I'm paraphrasing in terms that I understand. Ano ang tanong, sagot? Are you seeking clarification on what an attached agency is? What is it?
No po. We're confused po about the separate but attached agency po. So we would like to clarify that po.
It's separate. It's separate. Okay, here's my take. It's separate in that it's independent, but it's attached for budgetary purposes. Tama ba?
Yes, sir.
Pag-attached agency, ano?
Yes, sir.
According to the committee secretary, that is the definition of an attached agency. I think we have the same understanding na kapag attach for budget, no, sa budget.
Okay po.
But operationally, it's like it's independent.
Okay po.
Okay po ba tayo? Okay. So, and then bill must have clarifying complementary roles. CHR retaining its investigative and yung concern po ng TFDP naman, I think it goes to the overlap, ano? You don't want any overlapping functions. Must have provisions clarifying the complementary roles. CHR retaining its investigative and complaint-driven functions, and NPM focusing on regular preventive and proactive visits. To answer your question sa TFDP, wala naman po sa panukalang batas na ito na sinasabi na ang NPM ay may investigative at complaint-driven functions. The bill does not say, correct me if I'm wrong, the bill does not say that, or that does not provide the NPM investigative, now, the NPM committee, investigative and complaint-driven functions. Wala naman pong ganun eh. Tama? Does anyone concur? It doesn't say that. So therefore, if it doesn't say that, then its purpose is just regular preventive and proactive visits. So in other words, I don't think we need to clarify. Kasi hindi naman sinabing there's no confusion. Okay po ba tayo doon? TFDP. Maraming salamat po. Sa Philippine Alliance of Human Rights Advocates, I'd like to thank the committee secretary for summarizing all of this, so I'm not flipping pages. NPM must be independent, attached only for administrative support. Okay? Full autonomy in operation, staffing, budget, and reporting. Okay. Ito po ba yung siguro si Ms. Paulsen, tanongin natin. Yes. Ms. Paulsen, like, would you care to weigh in on, if you look at the table, PAHRA, or the Philippine Alliance of Human Rights Advocates, says the NPM must be independent. We all know what independent means. Attached only for administrative support. I take administrative support to mean budget. Okay? Full autonomy in operations. That the NPM will have full autonomy in operations, which is another way of saying that it's independent. I'm just staffing, budgeting, but this is staffing, budgeting, and reporting. In other countries, is there an analog that is helpful here? Like in the Philippines, we wanted an attached agency of the CHR, and yet we're saying it's independent. How about in other countries? What is the, are there analogs or comparables?
It's mixed. And I think overall there is a preference in the subcommittee to have the two bodies as independent as possible because they serve different functions. And you don't want contamination between the investigative you don't want the investigators and those who are doing preventive monitoring to be mixing in a way because it confuses the mandates. And in order to have also an open dialogue, for example, with prison officials, you don't want prison officials, for example, to be divulging problems they have in conditions if they think that it's going to lead to an investigation. I mean, that's the whole point of a preventive mechanism is to have it much more cooperative. So if you know that they then will go back and share information with the investigative body, you lose that separation. But in reality, what we often see in Asian countries and elsewhere, the Maldives, for example, is that the two bodies are connected, but then with sort of some kind of wall between them, and that can work. And I think it can work, especially in contexts where we've seen the Commission on Human Rights being accredited as a status commission, which it is here. It's independent. It's working well. So in that sense, it's not, there's not one model. It depends a little bit on the country status. And my understanding from speaking to national actors, but I will defer to others, is that this particular issue has been under debate for some time in the Philippines among the CHR and civil society, and this is some kind of wording that was developed, but I don't know exactly what the best solution is, but basically this is a national issue. You can decide on the model yourself a little bit.
I do appreciate but we appreciate that that the NPM should be independent, correct? In and of itself, there's nothing wrong with making it an attached agency to CHR, right? So, but looking at the language of Section 4 right now, do you think that that meets the concerns raised, where it says it's separate but attached to the Commission, it's separately, and it shall function separately and independently from the operations of the CHR?
Yeah, I think it's okay. It doesn't specify here a separate budget, and I would want to check, and maybe others here have more information on exactly what the subcommittee on the prevention of torture would say on that, because I think that is a distinction that's sometimes made.
Well, I'm looking at the appropriations clause. Can I see the appropriations clause, please? Director Fardo, you were raising your hand. Just to note, in the appropriations clause, it says the NPM shall have an initial budget of 900 million, the amount necessary of 900 million. The amount necessary for the implementation of that shall be charged against the current year's appropriations of the CHR. Thereafter, the amount necessary for the continuous implementation of this act shall be included in the general appropriation, annual general GAA. But Director Fardo, so there's a separate, there's an earmarking for NPM.
Sir. Sir, yun, concern ko is we've been focusing or stressing that it be independent, and we all agree on that, sir. The reason for yun focus on that is with regard to what will eventually be in the subsequent provisions of conflict of interest. Kasi sir, kapag halimbawa, if may second sentence na yan, sir, yan yung fear ko na baka hindi maging OPCAT compliant. So I'm targeting the second sentence. Yun, NPM shall be separate but attached agency of the Commission on Human Rights. Baka kasi, sir, maging conflict of interest issue yun, sir, sa subcommittee on the prevention of torture, which is the UN body that will declare that it's compliant with the OPCAT. Since it's not really required na nakalagay yan or dapat naka-attached sa Commission on Human Rights, maybe we could just remove the sentence for compliance purposes and focus on the independence as well as, so there might be a scenario, sir, which Ms. Sinya had said earlier, na separate yung mandates ng CHR tsaka ng NPM. Investigatory body po kasi si CHR.
Yes.
So CNPM is a
Visitorial.
preventive or visitorial. Tapos baka, sir, magkaroon ng conflict of interest if in the text itself of the law it appears that they're attached and beholden to the CHR. The point of the NPM is that it's not supposed to be beholden to the CHR, sir.
Correct.
Tapos kaya nagkakaroon ng discussions on the budget. Kasi, sir, yun sa budget minsan, sir, dyan na determine, sir, yung functional independence. Meaning is the independence functional.
If part of the budget of the CHR is earmarked for NPM, is that a problematic situation?
Would say, if it's already earmarked, sir, and if it's stated there na para sa NPM, sir, I don't think na hindi siya magiging issue ng independence, sir.
So going back to the appropriations clause, it says, asan ba yung shall have an initial budget that's directly from Congress of 900 million. That's really, talagang independent yan, direct mandate yan. The amount necessary for the implementation shall be charged against the current year's appropriation of the CHR. Okay yun. Thereafter, the amount necessary for the continuous implementation of this act shall be included in the GAA. Oh, okay yun. So, matatag yun. Hindi, kumbaga ba, hindi ka, sabi na, kung sinong may hawak ng pera, siyang bida eh. Siya yung hari. So, hindi ka parang tali. Di ba? So, that's a way of ensuring its independence, operationally. But maybe somebody was raising the hand. Attorney, help me, hindi ko makita yung pangalan.
Attorney Villasis, Mr. Chair.
Kayo po yung pinadala ni Attorney Leasing.
Yes.
Attorney Villasis.
It being an attached agency, also we have a concern under Section 13 of the bill on full fiscal autonomy because the CHR does not enjoy full fiscal autonomy, but an attached agency does. So there could be some, issue with budgeting, Mr. Chair. Could there be a possibility of providing for a budget under the GAA for
NPM?
the NPM committee?
Meron po, sinabi sa appropriations. So how about this? Why don't we, there's hereby created a NPM for the purpose of preventing torture and other cruel and inhuman degrading punishment. Is the problem, Attorney Villasis, the wording attached agency?
it's a concern, Mr. Chair, because the CHR does not enjoy full fiscal autonomy, and yet an attached agency under it enjoys full fiscal autonomy.
How about shall be under, well, you don't want to be under the CHR kasi parang you have the idea of, like a superior, no? And it's a subordinate. There's a hierarchy which you don't want that, right? Paano? Attorney Regalada, do you care to comment or?
Good morning, Chair. Good morning po sa lahat. Actually, Chair, the Commission opted for this structure phrasing based on the consultation that we had earlier with the different stakeholders. This is actually an agreement, or at least a middle ground for everyone, considering that initially when CHR was the initial proposal was the CHR to be designated as the NPM, as what we have presented yesterday. Ito po kasi yung talagang karamihan ng NPM na established in other countries. It was not actually, it was raised as a concern po, considering that the independence of the NPM might be questioned. So the NPM as attached agency was actually proposed, not only because of the result of the consultation. It was also actually suggested because it will be easier for us to pass a bill without creating a new commission, as it will be in terms of resources, it will be more more ano po siya, acceptable. So it's actually more of a strategy. But on the part of the Commission, as long as a bill will be passed establishing the NPM, we welcome naman po then, as long as it will be accepted po.
Attorney Villasis, do you have proposed wording? You seem to be allergic to attached agency. Oh, so what is your proposed wording?
I have no exact proposed wording, Mr. Chair, but the idea is to be very specific what is the engagement, or at least what are the areas that will be performed by the CHR insofar as administrative functions are concerned. Because our position from the UPIHR is that, again, aligned with the international standard, that the NPM should be autonomous insofar as its operational mandates are concerned. But that was only a concern that I raised, Mr. Chair, because I do understand that there are pending bills for the CHR charter that would want the CHR, or that would strengthen further the function of the CHR as NHRI with full fiscal autonomy. But in this bill, wherein we have an NPM as an attached agency in this, with the CHR, it does enjoy full fiscal autonomy. So there could be some concerns, Mr. Chair.
Attorney Villasis, so you're saying that attached agency implies full fiscal autonomy. Is that legally defined? Does it follow that you say attached agency, then the legal understanding is that it has fiscal autonomy?
It does not necessarily follow, Mr. Chair, that the CHR will enjoy also full fiscal autonomy. But the NPM...
No, the NPM. I'm asking about the NPM.
No, Mr. Chair. My concern is with the relationship between CHR and NPM. CHR as NPM as an attached agency to the CHR.
No, because you said the CHR does not have full fiscal autonomy.
Yes.
But because the NPM is an attached agency of the CHR, then this NPM has full fiscal autonomy. You know, sinasabi, I think
Yes.
that, right? Because, so in other words, what led you to believe, or what led you to that interpretation, are the words attached agency, which to your mind means if you're an attached agency, you have full fiscal autonomy. Because otherwise you wouldn't be saying that.
I'm reading Section 13, Mr. Chair, in relation to the attached
Ano yung
agency.
13? I understand. Yun nga yung sinasabi ko.
It's a direct provision on fiscal economy.
Oh, I see. I see. Okay, section 13. I didn't factor this in. I thought you were just focusing on I understand what you're saying. The water can spring higher than its source.
Yes, Mr. Chair.
Diba? It can be higher than its source. I agree with that. So, okay. Ma'am, Miss De Hoya, ma'am, you have the floor.
If we can propose the NPM as a separate but attached agency of the Commission of Human Rights on Human Rights, while guaranteeing functional independence consisting with OPCAT requirements. Yung as a formulation for that.
Can you elaborate on that just so, you know, kind of explain why that would address the concern, please?
The NPM as a separate but attached agency of the Commission on Human Rights while guaranteeing functional independence consistent with optional requirement, OPCAT requirements. Yun po yung isang formulation.
Ms. De Hoya, and I think Attorney Villalobos will agree, it doesn't really address the concern of fiscal autonomy, which is in Section 13, right? Tama ba? That suggestion does not address that. Because in Section 13, ang sinasabi po ni Attorney Villalobos, the CHR right now does not have fiscal autonomy. Correct? But the bill provides that the NPM has fiscal autonomy. That's in Section 13 of the bill. If you leapfrog to Section 13, it says fiscal autonomy. Right? So, how can it be that an attached agency has fiscal autonomy and yet the mother organization, entity, does not have fiscal autonomy? Yun ang sinasabi niya.
If I may, Mr. Chair,
Attorney Villalobos.
on behalf of the UPIHR, we do believe that the CHR should be granted full fiscal autonomy.
No, I agree.
Yes, Mr. Chair.
But that's not the case right now, right?
Yes po.
And that's why they're legislating the charter.
Yes.
Yes. What is the status of the charter? Just as an aside. Okay. Okay, so Director Fajardo, is fiscal autonomy essential for the NPM?
Sir, I'll address it in relation to the statement already regarding the CHR, sir.
Go ahead.
Okay. Sir, the difference of yun CHR, sir, as well as yun with regard to the NPM is that existence of CHR, sir, is with regard the framework that the UN uses is what they call the Declaration on the Independence of National Human Rights Institutions, which is in short the UN Paris Principles. Ngayon, sir, dun sa UN Paris Principles with regard to the existence of CHR, hindi nakalagay dun, sir, yun fiscal autonomy, sir, as like yun separate branches of government na executive, legislative, and judiciary. Ngayon, sir, dito sa National Preventive Mechanism sa OPCAT, sir, nakalagay kasi, sir, na independent siya dapat and may fiscal autonomy, sir. Ngayon, sir, hindi siya, I'll just say in practice, sir, it's not really that strict with regard to dun sa fiscal autonomy. So long as what you had earlier stated, yun appropriations provision, sir. Basta may distinctive and clear appropriation, sir. And that's a practice. And
Kasi alam ko naman yung function eh. Ang gusto lang ng batas na to, ma-implement. And to implement this, kailangan may pondo na hiwalay para hindi siya nakadepende rin sa ibang ahensya. Di ba? Dahil kung nakadepende siya sa budget ng ahensya at silang may kapangyarihan na kung paano gumuguling yun, baka maapektuhan yung operations na NPM. So are you proposing, Director Fajardo, to delete fiscal autonomy? Since the appropriation clause says that they will enjoy separate funding.
Sir, I'm not going to propose the deletion, sir, for purposes of just compliance, sir. So
But you said that fiscal autonomy, let me rephrase the question. If we delete the fiscal autonomy provision, Section 13, would we be OPCAT compliant?
if we retain it, sir.
If we delete it? Section 13.
Yes, sir. It's pleasant to the eye, sir, for like the UNSPT.
To see fiscal autonomy.
To see that as a provision, sir.
But,
It's,
but if you look at the appropriations clause, isn't that fiscal autonomy? Appropriations clause.
Sir, we're delving on a term which is in context sa Philippines. But what we can propose, sir, is based on the wordings used ng UN guidelines, which uses functional and operational financial autonomy.
Ganon din yun eh.
Ginamit na term, sir,
Financial,
complete.
fiscal autonomy, as I understand, kasi we've been using those, we've been mentioning fiscal autonomy without defining it. My understanding of fiscal autonomy is financial independence. So therefore, earmark provision, guaranteed funding from Congress, right?
Sir, kasi sir, yung focus niya is yung financial and operational autonomy so long as it's budgeted and it can operate in such a manner, sir.
So if you look at the appropriations clause, shall have initial 900 million charged against the current year's appropriation. So sinasabi ng Congress, isi-set aside the 900 million. Tapos, the amount necessary for the continuous implementation of this act shall be included in the annual general GAA. Ang sinasabi niya ganito, for now, kukunin sa CHR, 900 million. In the future, line entry, separate line entry, hindi mo na makikita under CHR yan. Di ba? Yun ang sinasabi yan. So therefore, I go back to my question. And the only why, and this will also, it is relevant to the point raised by Attorney Villasis, kasi sabi niya, how can it be? The CHR has no fiscal autonomy and yet you have fiscal autonomy, right? As an attached agency. What if we do this? Tanggalin natin yung fiscal autonomy. That provision, Section 13. Tanggalin natin Section 13. It's an attached agency. Pero attached agency pa rin siya, but go ahead.
Mr. Chair, it's just an inquiry po. Possibly po kaya we provide a provision doon sa budget that to the effect na it will be treated separately when it terms to budget so that we can put in full force in effect doon sa provision on full fiscal autonomy.
Well, the second sentence says that. Thereafter, the amount necessary for the continuous implementation of the act shall be included in the annual GAA. Notice that there's no reference to CHR in the second sentence. So sa una, CHR muna, doon kukunin. But subsequently, separate na. Nakalagay doon eh. Yun ang reading ko ah.
Yes. To my mind also, Mr. Chair, that will give effect to the provision on full fiscal autonomy.
So therefore, the provision on full fiscal autonomy is surplusage.
But full fiscal autonomy, Mr. Chair, does not only mean that its budget is secured. There are also other guarantees for full fiscal autonomy.
Such as?
Such that it will not be under the DBM, so it has the liberty to propose its own budget without, the interference by the DBM.
So how would you revise going back to Section 4 to address your concerns?
If that was the interpretation, Mr. Chair, of the second sentence of Section 20, then that will give force in effect to the provision of to Section 13. So I think we can still retain Section 13 and full fiscal autonomy if thereafter its budget will be treated separately and
Right.
independently from that of the CHR.
Fiscal autonomy, nasabi. Yung wording. Yeah, so you're saying fiscal autonomy, Section 13, is a restatement of the second sentence of the Appropriations Clause. The second sentence of the Appropriations Clause is a restates.
Not necessarily, Mr. Chair. Section 20, second sentence speaks about separate treatment of the budget of the NPM. Section 13 speaks of the full fiscal autonomy because that is the problem with CHR right now, Mr. Chair. It does enjoy fiscal autonomy, but the Supreme Court in many cases said that it is not full fiscal autonomy. It's
Can
only
you please
relative.
define what fiscal autonomy is?
If I may read, Mr. Chair.
Sure. And then we will turn to Ms. De Hoya regarding her. Oh, actually, no, it was Director Fajardo yung functional and autonomy. Sige, we'll turn to that.
So basically, Mr. Chair, if I may, so full fiscal autonomy does not merely mean that the budget shall not be decreased and it shall be released automatically without any condition. It also includes autonomy as regards the independence of the body to decide what to which part or where should this be where the budget should be allocated. That may also include the creation of offices or positions. I think, Mr. Chair, if Section 20, the second paragraph, means that its budget shall be treated separately from CHR, that means that after the first year of its operation and thereafter, Mr. Chair, it shall enjoy full fiscal autonomy, considering that it will not be dependent on the CHR, even if it is an attached agency under CHR po.
So that's okay with you?
Yes, Mr. Chair, if that is the interpretation of second paragraph of Section 20 po.
Yeah, it enjoys separate funding. It's why it's saying in Section 20 that NPM enjoys separate funding, right? And then for emphasis, you have Section 13, fiscal autonomy. You're batting for its retention?
Yes, Mr. Chair.
So you would retain that. Ensure that the NPM shall enjoy full fiscal autonomy of provision of the NPM.
They do not allow yung mga maglalagay ng amount. They discourage that.
How about this? What about we delete the first sentence of Section 20? The NPM shall have an initial blah blah. We just say the amount necessary for the implementation of the act shall be included in the GAA. Yun, talagang autonomy yan. Pwede ba yan? That's better. Matutuwa yung CHR. Sabi niya, yay, 900, nakatakas tayo sa 900 million. Miss Sevilla, sabi maliit na nga budget namin, tatagal pa ng 900 million. Miss Sevilla.
Pero pag ganun kasi, sir, kung halimbawa na enact na siya, tapos wala pa siya sa GAA. So, paano yung... Kaya po yata siya naka-charge sa budget ng CHR.
Tama din naman yun. Kasi We'll just, the NPM shall have the amount necessary. Okay? The NPM shall have, tanggalin na yung amount. The amount necessary for the implementation shall be charged against, yun. We'll just delete the first sentence. Diba? We have more flexibility. Kasi we don't want this to provoke controversy at the Committee on Appropriations. The moment you give an amount, then you have to justify it. Diba? So, my suggestion, unless you feel, you have concerns, is that, what if we delete the first sentence? Just start with the amount necessary for the implementation of the act shall be charged against the current year's appropriation of the CHR. Thereafter, amount necessary for the continuous implementation of this act. Pwede ba na natin, the amount necessary for its continuous application, para hindi paulit-ulit yung of this act, shall be included in the annual GAA. Ganun yun lang. Diba? Okay po tayo doon. So that still says, there's still fiscal autonomy with a revised language. And then we're going to keep Section 5. But going back to the original issue raised by Attorney Villasis, how do you reconcile that the CHR does not have fiscal autonomy, and yet this one has fiscal autonomy as an attached agency? Diba? Parang, so maybe we can reword Section 4 on the NPM. Director Fajardo, what was your proposed language?
I was proposing the removal of the second sentence, which is the NPM shall be separate but attached agency of the Commission on Human Rights, such that there will be only two sentences, sir.
So the sentence there is thereby created national plan for the purpose of preventing torture and other yan. Oh, teka. You're deleting sentences 2 and 3?
No, just sentence 2, sir.
Tingnan natin, delete section sentence 2. So there's hereby created a committee for the purpose of preventing torture or it shall function separately independently from the operations of CHR. Yeah. How about that? Does that address your concern, Attorney Villasis?
Yes, Mr. Chair.
Other concerns regarding the Section 4 as revised? Ms. Sevilla.
Pag tinanggal po yung sentence na yun, mawawala na yung element ng pagiging attached agency niya sa CHR.
Why is it important that it be an attached agency?
Para po ma-justify na yung initial budget din niya ay kukunin dun sa...
The justification is in the appropriations clause. We just said allocate, get it from the CHR.
Pwede.
Tinan mo yung appropriations clause. Section... Oh, ayan, no? Tanggalin, hindi, as revised. Where is it? Na-revise na natin yan. Oh, ayan, no? Look at the right side. Ang kailangan lang niya kasi sa CHR, pondo, the initial funding. Di ba? Tama? Attorney Villasis?
May concern din po, Mr. Chair,
Ganyan talaga pag lawyer, maraming concerns. Sige,
No,
pagpatuloy mo.
May concern lang po, Mr. Chair, sa admin staff, pareho po sa HR, accounting. I think that's the reason why it is attached to the CHR. Para yun yung shared offices nila. But, yun po.
How about attached agency for purposes of, lagyan natin ganon. Can we do that? So going back to section 4,
Agency, ibig sabihin policy and program coordination lang. It doesn't mean na naka-house sila dun sa building nila. Yung minsan may governing board member siya dun, pero it doesn't mean na same office or same ano.
yun nga. So it really it would help to know the intention of the why we use say attached agency. You know, it goes to actually the definition of what attached agency. If there's a baka naman we have our own subjective interpretation of what how yung attached agency, how is it attached, for what purpose, di ba? With respect to funding, we already addressed that. We said separate funding, right? All right, so here are the questions that maybe the CHR can weigh in. Are they going to be housed in under the same roof, right? What about policy and program coordination? Meron bang ganon? But that will raise conflict, ano? Yung conflict issues. Meron bang reporting? What are the dynamics between CHR and NPM? Okay? So, for this, I think we need guidance, from OPCAT and also in other countries. What are the dynamics between like a CHR body, Commission on Human Rights or counterpart in other countries, and NPM? Ms. Paulson.
I mean, you can set it up in whatever way is more appropriate. My understanding in the Philippines is that there is not a great appetite to create a big number of expensive new institutions.
Yes,
so
bureaucracy, we hate it.
Yeah, well, I mean, every country, right? But that it would be efficient to, for example, have shared premises, to use the same administrative systems, to use those established procedures, but also the expertise that exists within the CHR. And of course, it's not only centrally, but also in the 17 regional offices of the CHR. I will let the CHR talk about the details of it, of course.
I was going to turn to the CHR.
One final thing, I was wondering if the main issue is this issue of fiscal autonomy, which the SPT, in fact, made a comment on Article 13, I saw, so it's probably good to retain that. But attached is not subservient, right? Or it's not a subsidiary to the CHR. And so I wonder if that makes, it's just a question if that makes a difference in the terms of the problem with fiscal autonomy, because if they are just attached agencies, maybe it's okay that one has fiscal autonomy now, and then hopefully the NPM bill would be adopted, the CHR bill would be adopted at some point, so that issue is also resolved. Just a question. Thank you.
Or maybe if we change the word attached to affiliated. I don't know. But maybe can we hear from the CHR, and then I'm going to turn to Director Fajardo, only because, if it's depending on the dynamics between NPM and CHR, with respect to policy, I see, I see why the CHR is a relevant agency, because it's concerned with promoting, its focuses on promoting human rights, as with the NPM. But the concern now is that the dynamics, does it pose like conflict of interest issues, conflict of interest issues, given the respective mandates of CHR and NPM. But operationally, Like, what does the CHR envision? Are you going to have the same staff? Is Attorney Regalado be part of the NPM? Or in which case it would Attorney Regalado would bat for the retention of the 900 million. But what exactly operationally, how can you, how do you envision this relationship between CHR and NPM? I mean, not talking about the mandates, I think we're settled on the mandates. We know that that has been defined by law, by the Constitution actually, and here we have defined the functions of the NPM already, and they're distinct responsibilities. But go ahead.
The vision really for the NPM, why it's classified as an attached agency to the CHR is for purely admin and budget purposes. In previous Congresses, when we were trying to lobby for the establishment of an NPM, there were issues on budget, on establishing an entirely new entity, an NPM, that would take more budget in terms of staffing, in admin, in renting buildings, in having regional presence. So that's why the logic behind having it attached to the CHR is if it's attached to the CHR, then it can take advantage of the existing admin structures of the CHR. The CHR already has a budget na pwedeng ikabit yung line. Its regional presence, the NPM would have a sort of meron ng bahay sa mga regions if it's attached to the CHR. So in terms of budgeting, it wouldn't take millions and millions of pesos to create an NPM if it's attached to the CHR.
So you mentioned for administrative and budgetary purposes, right? But here, for Section 4, it's just administrative purposes because we already discussed the budget earlier, like the appropriation. So would it help to say the NPM shall be it shall function separately and independent of operations. Okay, you said that it's an attached agency for administrative purposes. Is that consistent with the last sentence? It shall function separately and independently from the operation of CHR. Consistent? Independence, talagang non-negotiable yun. It has to be independent. Shall function separately from the operations of CHR. Is that consistent with? Okay, consistent attached agency. Okay, so I'm proposing this. There's hereby created an NPM committee for the purpose of preventing so on and so forth. The NPM shall be an attached agency of the CHR for administrative purposes. Any concerns? Attorney Villasis, for administrative purposes, it's an attached agency. Kasi without the additional description or modifier for administrative purposes, you might think then the issue the water springs higher than its source. That becomes an issue. The hierarchy. Go ahead.
I'm okay if there will be a qualification, but maybe will it not be restrictive, Mr. Chair, if we're going to confine it to administrative, because maybe the CHR also envisions other functions, such as the sharing of offices, etc.
Di ba admin yun?
Admin na po ba?
Is that considered, now we go to a definition of what's administrative purposes. Administrative purposes, what is the CHR's understanding of administrative purposes? Are you talking about the physical or sharing space, correct? Sharing space?
Chair, so long as it's not included in the core mandate, the protection, prevention, policy, and promotion,
share
that would be
personnel-
support to operations. So that's admin for the Commission on Human Rights.
Is if you share personnel, is there a risk of conflict of interest?
Personnel for administrative office, administrative personnel chair.
Ah, okay. But okay, given that, hindi ba nakakuha yun, administrative purposes? Administrative purposes for me means office. Di ba? Personnel. Right? Except for the NPM itself. Administrative purposes, according to Google, says, refers to actions, processes, or decisions done strictly for the management, organization, internal operations of a business, government, school. It means something that's done to keep an organization running smoothly rather than for its core, rather than for its core creative, commercial, instructional work. So it doesn't go to the strict mandate, no, the core mandate. It's just operational. How about for administrative and operational purposes? Ayun. You mentioned, was it the Director of RD, functional?
Operational autonomy.
Fiscal and operational.
So I could, financial and operational autonomy, sir. Sir, with regard to what we're discussing right now, sir, there's a guide for it, sir. Yung tinatawag natin na UN guidelines on national preventive mechanisms, sir. It specifies in items 31 and 32 that if yun 31 and 32, sir. Yun yung discussion natin, sir.
NPM members. Okay. So with its own staff and budget.
Bali separate siya, sir.
Oo.
Hindi nag-intermingle, sir, yun operational aspect, sir. It's to such an extent, sir, na kasi pagka ganyan, sir, yung unit namin, sir, is nag-aagawan, sir, sa, like, example ko, sir, mababaw, sa motor pool, sir, sa kotse. So pagka may visitorial mandate ito, sir, in the same manner na si CHR has a visitorial mandate also. Mas stringent pa sa kanya kasi enforced disappearance yung ginagawa ng CHR, sir, reactions.
Pero I think what they're contemplating is, no sharing of core personnel, with respect to the core mandates, versus say admin, backroom, like, di ba yun ang, that's what you're contemplating. So yeah, kunyari, mga tipong, what are the admin tasks that doesn't,
Chair,
the non-core?
yes, non-core, anything that supports the operation, personnel, budget, planning, procurement, so everything that supports operation. Operation would be protection or investigation, legal, prevention, policy, and promotion. So that's operation. Anything that supports operation, that's admin. So motor pool would go into admin.
Okay. So, okay, given that, is that distinction acceptable to you? Aligned with your thinking?
Pwede na siguro yan, sir, yun details kasi yun ang tawag doon
IRR.
bog down tayo, sir, sa details masyado.
Because if we say, for administrative purposes. For administrative purposes. And then when they threshold the IRR, we know not to introduce like sticky situations and situations that are fraught with that raise the possibility of conflict. So igaganon yun sa IRR pagdating sa IR, yung core, talagang separate talaga. And then, what supports the core personnel, yun ang admin. So, okay na ba yung for administrative purposes? Okay. Yes.
Sir, kasi the principles under the OPCAT, it speaks of independence, impartiality, non-selectivity, and objectivity. So baka sir, pwede may ilagay sa IRR yon with respect to the para klaro sir na nako-comply yung OPCAT principles na nabanggit ko sir.
Why don't we include it in this last sentence? It shall function
Separately, independently,
ano yung tatlong
from the operation of CHR, following the principles of the OPCAT on independence, impartiality, objectivity, and non-selectivity.
Is that good? So, subject to refinement, you mentioned independently twice. So, I would say it shall function separately from the operations of the CHR pursuant to
the principles of the
principles of OPCAT on
independence,
impartiality,
non-selectivity, and objectivity.
Yon. So, tatanggalin mo na yung independently kasi it was mentioned twice. So, it shall function separately from the operations of the CHR pursuant to the principles of OPCAT on
independence, impartiality, non-selectivity, and objectivity.
Non-selectivity, no?
Yes, sir.
And I guess in the
objectivity.
And objectivity. And those terms are defined in OPCAT.
Yes, sir.
Okay. Awesome. Ipo-proofread na lang yan. Okay po ba tayo dyan? Okay. So, the Section 4 as revised is adopted. Moving on to Section 5. Ito na. Thanks. Powers and functions of the NPM. Ay, mahaba to. Ilang letters? L. Okay. So, the following have submitted their positions. DSWD, APT, Balay, UNSPT, PNP, Bucor, APT, TFDP, DOH, NBI, Bucor, Balay, NBI, FIND, and UP Institute of Human Rights. Okay. May we hear from DSWD first?
Good morning, Mr. Chair. We would like to suggest po that you should explicitly direct NPM to formulate appropriate interventions that prevent torture and ill treatment against vulnerable persons, particularly children, women, older persons, and PWDs, because these sectors are highly at risk due to their physical, psychological, and social vulnerabilities, thus require targeted preventive and protective measures po. Thank you.
First, does that overlap with the mandate of CHR? Yung formulate appropriate interventions that prevent torture.
Appropriate interventions that prevent
Attorney Asiponia.
There's a slight overlap in terms of the CHR under the Anti-Torture Act of 2009 is also mandated to review policies of relevant government agencies in terms of their mechanisms in preventing torture, in screening torture. So there's a little bit of overlap in that in relation to the SWD's comment, but we think that this is fine, that CHR still does it because it's based naman on the Anti-Torture Act, and having the NPM also do it would actually benefit everyone kasi it would double the effort to have mechanisms that would prevent torture.
Is there, from OPCAT, do you see any problem with that? Formulate appropriate intervention that prevent torture and ill treatment? None?
It's just that there's room, sir, for a conflict of interest. That's all. There's nothing on the text itself. There's nothing not compliant with all.
Okay. How likely is a conflict? How real is that concern? If CHR is doing it and if the NPM is doing it, both are formulating appropriate interventions. He said it is fraught with risks of conflict of interest. Like,
sir, CHR, sir, has a specific mandate, which I do understand that they can respond to reports of torture, sir.
oh, sorry, can you repeat that, please? Sorry.
Sir, si CHR, meron siyang mandate. Yung kaninang discussions natin with regard to yung visits. Yung visits na yun is based on the Anti-Torture Act, which is yung pagbisita nila dahil may reported torture, sir. Si NPM doesn't require that particular mandate. They do so based on a schedule or a program, and then they do that mandate. Ngayon, sir, if they're already together with yun tungkol dun sa administrative aspect, nagkakaroon, sir, sa akin, sir, from my perspective, just bureaucratic, nag-aagawan sila, may possibility na magkaroon ng conflict of interest there. Not that it's wrong or it's bad, sir, but it's just that there's room for conflict of interest.
Is it correct to say that the perspective of the CHR is more remedial, and then yung BNPM is preventive, more systemic?
Chair, it is correct that our mandate is really reactive or responsive. We respond to reports of or allegations of human rights violation, but we also have a preventive mandate, the Commission on Human Rights. That's why we have the vistorial mandate, wherein we visit places of deprivation of liberty to ensure that there are no human rights violation or any incidents of torture. So in that sense, there is actually an overlap between the mandate slight overlap between the mandate of the CHR and the NPM. That's why we are saying that
How would you respond to Director Fajardo?
The question is on the sharing of resources at Director Fajardo, or go ahead.
Bale, ma'am, kasi kanina nag-uusap tayo dun sa unrestricted visits, and we have agencies, security sector agencies who are managing, supervising, or administering to places of detention. Ngayon, sir, when they do so, yun ginagawa nilang preventive visits, it may add on. I can't say that it's conflict of interest, more on confusion with regard to the places of detention. When they do those visits, nagko-compete, sir, kasi nga, not that I'm even saying it's wrong. They may compete with the time as well as yung nag-a-add ng confusion kasi nga si place of detention will now have two entities
Two sets
in
of
one
personnel.
body.
Magkaiba ng personnel nila.
Yes, sometimes in one physical location in office, conducting different versions of a visit.
Yes.
Yun lang, sir, yun sinasabi, sir.
Attorney Esteponia.
Well, we in terms of distinguishing CHR from NPM, CHR kasi meron siyang both reactive visits and preventive monitoring visits. But the difference is, if it's CHR that discovers torture or ill treatment in the course of its preventive monitoring visits, it has the obligation, the prevention office has the obligation to immediately refer that to our investigation office, which immediately triggers an investigation process on the place of deprivation of liberty, on the agents involved. The difference is, for NPM, it doesn't have that immediate trigger. So when the NPM conducts its visits, it does so na preventive monitoring. Tapos, pag may nakikitang problems, ang immediate na kinakausap is the management of the place of detention. So parang, oh, this happened, what are you going to do about it? What are your interventions? Versus CHR na, oh, this is already an HRV, we're going to investigate. So yun yung difference. Operationally, it's actually cleaner because that's an issue also of the CHR right now. The ones conducting investigations are the same staff doing preventive monitoring visits, which actually contributes to kaya nako-confuse ang AFP, ang PNP, ang Bucor, because bumisita, nag-preventive monitoring, pag may na-discover, it's the same people conducting investigations. Versus if we have an NPM na ibang tao, ibang staffing, it's very clear na pag CHR, oops, pwede tayong investigahan, pwede tayong dalawin ulit for a round of investigations. Versus NPM na, pag NPM hat, ibang tao, ibang mukha. Alam nila na kakausapin muna kami. This will be parang an in-house remedy muna before this becomes a big thing. Kasi preventive monitoring yung NPM po.
Oh, maganda na may sagot niya. Okay. So going back to the question, is there a need to include a mandate to formulate appropriate interventions? Okay, parang wala naman eh. Right? So the question, so DSW proposed that. I take it you didn't find that wording in the list? That mandate in the list? That's why you're proposing it? Tama? Hindi ba nahagip ng mga nakalista dyan? DSWD Attorney Asis? Unannounced visits, preventive monitoring, examine national laws, submit to Congress report. Ayan, hindi ba nahagip nung ano yan, letter D? To submit to Congress and the President's annual NPM report which shall contain its observations, advisories, and other policy recommendations and proposals relating to the rights of protection of man. Oh. And also, if you look at letter G, to publish information relative to its preventive monitoring functions.
Yes.
Speaking on matters mentioned in A, B, C, D, E, which D I mentioned earlier, when circumstances so warrant with due prudence. Oh.
Okay na po.
Okay na yun, di ba?
Yes po.
Okay. It's, I think it's comprehensively worded. I mean, broadly worded to include the particular mandate that you want the NPM to do. So that has been addressed. Now, you mentioned also, sorry, DOH pala to. Okay, now I think that we have addressed the concerns of DSWD. Now, turning to APT. You may merge 5 and 6 to avoid unnecessary repetition confusion. Sections 5 and 6. Guarantees for the NPM. Hindi ba parang nasagot na ito kanina? Yung access to information, unrestricted. Hindi, definition of terms. Okay. Can we hear the APT?
Chair, ang APT po ay Geneva based. Wala po sila ngayon dito.
Wala. They propose to merge 5 and 6 to avoid unnecessary repetition. Confusion may result from the duplications that are present in the current draft. 5 and 6. Itong functions and the guarantees. Functions and guarantees. And also, I want to say that Section 6, kanina we discussed yung unrestricted access, no? And we adopted OPCAT for that. I want to say that if we're going to keep Section 6, it should be aligned with yung definition kanina, yung OPCAT, yung wording doon. Yung access to all information, access to all, yung mga ganon. Yes. We adopted this? No, we defined as we revised E, no? Hindi yata yung flash mo. I didn't see the word unrestricted.
This is the
Iba yung flash mo kanina, access lang nakalagay mo. Kasi, ito lang ako ganito. That was a different draft.
guidelines.
What did you pass kanina? Yung sa OPCAT?
Guidelines lang. Sa guidelines.
Can I see the guidelines? Yeah. Was it Article 20? Yung, what?
This is Article 20.
Oh, yun, nalito ako, yes. So, what I'm saying is that this should be aligned with this. Kasi, it talks about information, places of detention. Can we just briefly go to Section 6? On the guarantees for the NPM. Shall guarantee the NPM the following. Do you agree that this should be consistent with yung kanina, yung OPCAT? So, if we go to Article 20 of OPCAT, actually go as we revised earlier, if you go to the actual revision for unrestricted access in the definition of terms, where is that? Yung OPCAT, Section 20. Ano yun eh? Yun yung ganito kinuha natin. Tapos dinify ba yung... Where is the language? I thought we revised it. Where is it? Nawala. On paragraph E. Oh, hindi pa napapalitan? I thought we revised it already. Kasi we made it the liberty to choose the places they want to be and the persons they want to interview. And then was it pursuant to something? I don't know. What language did we use? Akala ko nagawa na natin.
subject to style na lang.
So, nasan yung...
I think letter 3. Ginagawa natin yun, diba?
Binago yung E. Places they want to visit pursuant to whatever section, persons they want to interview as enumerated in ano. They want to visit as enumerated.
K, nasa K po. Sa K. Paragraph 3.
No. Yeah, okay. Just going back. Itong unrestricted access was completely replaced by OPCAT. Completely replaced by OPCAT yun. Section 20. And then, we just revised letter E. The liberty to choose the places. And then there's a reference, you were pointing back to a previous section. And the person they want to interview, you're pointing back to a previous section, ganun na revision doon. Okay? So, we have to reflect that. Now, pag na-revise mo na yan, dadali mo ngayon yan sa guarantees for the NPM. Because magkahawig eh. If you go to the guarantees, that's section 6. Now, if you could insert the revision there, you can do a side-by-side comparison. Tingnan mo. Yan. Tingnan mo. Tama? So, if you're going to keep section 6, kasi there was a suggestion to merge it with section 5. You know, I don't feel strongly about that because I don't think their 5 and 6 are conflicting anyway. This is guarantees for the NPM is directed to government that you have to provide the NPM access, the following. Di ba? Di ba? Yung isa is the power of the functions of the NPM. So magkaiba po yun. One is directed, guarantees for the NPM is directed to government. Powers and functions are defined the responsibilities of the NPM. So, ito, ang suggestion ko lang po, nagugutom po ba kayo? Hindi naman. Kumain kayo. Gusto niyo bang second round? Break? Wellness break? I'll just leave with this thought first before we go on break for 45 minutes. Hindi, loko lang. Kailangan align lang yan. Yung A is access to information. Kasi we already agreed on this, otherwise we'll debate this all over again. Unrestricted access to information. Yun na yun, no? I-align lang natin yan. So the wording will be, all branches, subdivisions, departments, and agencies of instruments of government and relevant private institutions shall guarantee the NPM the following. Ayun, that's A, B, C, D, E. E will change. Nirevise natin kanina yan. Okay? Can you do a highlight on E? To indicate that that will be revised. Yes, you will do the reference. You will, there's a reference to other sections there. Yan. Shall provide, and so the wording is, the NPM shall provide the following, include sa letter F, the right to have the contacts with the CN. Okay. Down? Yun na ba yan? Okay na po ba tayo dyan? Ha? Okay tayo ito, di ba? Guarantees na naman yan eh. So, Section 6 is adopted as revised. Going back to Section 5. Section 5 tayo. Concerns of DSW have been addressed. APT, we have addressed that. Balay, define unambiguous authority over access. Ambiguous authority over access, inspection, reporting to prevent administrative and political interference. May we hear from Balay?
Thank you so much, Sir. Yung comment na yun was basically an observation to letter B.
Letter B.
Parang ang concern lang is, would it be a good idea to, at some point, or maybe sa IRR or elsewhere, to have a clearer definition or determination who these authorities are. Well, kasi in our mind, for example, kung sa BGMP yan, sino bang kakausapin dyan? Chief BGMP, DILG,
Opo.
something like that po.
Sige po. Gagawin natin, mag-break muna po tayo for 5 minutes, if you don't mind. And then we'll go, after the break, we'll discuss till 1 p.m. 1 p.m. ako? Ang dalawang bills ko? Pero yung bills ko, dalawa? 1 p.m. Sa rules? 1 o'clock yun. And then I will take like a 15-minute break at 1 o'clock. And then babalik po ako dito. Is that good? Kaya, Comsec. Para sagarin na natin. Sige. Pero, re-refer lang naman yung... Why do I need to do that? Mabilis lang? Sige, break muna po tayong 5 minutes. Okay. We'll resume the consideration of this bill. We'll go for another 15 minutes, and then we'll take a 15-minute break, and then I'll be back after that. So we're now on Section 5, Powers and Functions of NPM. I take it that the introductory statement is okay. The NPM whose visiting mandate is specifically aimed at the prevention of torture and other cruel, inhuman, or degrading treatment or punishment, and proactive and non-adversarial approach shall have the following powers and functions. Wala tayong problema sa simula. Okay? There being no objection, okay, the first part is adopted. Now let's go to letter A, which we touched upon earlier. To conduct regular unannounced visits to places of deprivation of liberty in order to prevent torture. So on. In conducting such visits, the NPM may consider requests for visits by civil society groups or any entities or individuals regarding policy, procedure, or practical reforms in places of deprivation of liberty. Okay, we already discussed unannounced visits earlier, so I take it this is okay. Okay. So, letter A is adopted. As with the introductory clause, I failed to bang the gavel for that, so I'm banging it now. Okay. Sa letter B po tayo. To undertake preventive monitoring visits and coordinate with relevant authorities to examine and assess the custodial policies, procedures, practices, and all other aspects relevant to the treatment and living conditions of persons deprived of liberty in order to identify the risks that give rise to torture and other cruel, inhuman, degrading treatment or punishment in accordance with the UN Standard Minimum Rules on the Treatment of Prisoners and existing international principles, obligations, and standards. The DOH says the distinguished NPM monitoring visits for inspections conducted by the IRB to ensure complementary oversight and avoid duplication with existing regulatory. Integrate health promotion principles. What do I say? Is the DOH? Can you elaborate on that? Dr. Domingo?
Yes. Thank you, Mr. Chair. So for the first comment from the DOH, as for distinguishing NPM monitoring visits from inspections by the internal review boards, or IRBs, this is in line with the Mental Health Act as stated in RA 11036, as well as with the joint administrative order with the CHR in establishing IRBs. So, Mr. Chair, the IRB functions to inspect any complaints, basically to review all cases, disputes, and controversies involving the treatment, restraint, or confinement of service users, or that is mental health facilities. So while we do acknowledge that the functions outlined of the IRBs complements with the functions of the NPM, we just want to make sure that these don't overlap.
The NPM visit, the purpose of that is to identify the risks that give rise to torture and other cruel, inhuman, and degrading treatment or punishment. Isn't that, doesn't that differentiate it from the IRB visits?
Well, there's some overlap because as per the wording of the Mental Health Act, the IRB functions to review cases of involving treatment, restraint, or confinement. So if there's perceived overlap, but we just want to clarify that these two are complementary.
CHR, do you see any overlap? Actually, before the CHR, sorry, Ms. Paulson.
I'm not sure I see the overlap because you're talking about individual cases that are happening and that need to be addressed, whereas an NPM would probably come in and say, do you use restraints here, rather than looking at individual cases and then make recommendations on whether to use them or not. So I think this is the distinction.
Yes. Do you share the views of Ms. Paulson?
Yes, Chair. IRB is more of a reactive visit, response to complaints, whereas NPM is more preventive. In fact, Chair, if I may add, the CHR is also doing a preventive visit to Mental Health Act. In that sense, there are
Same concern.
Same concern earlier.
Yeah. Okay. So I hope that addresses your concern. And then you mentioned integrate health promotion principles and international health standards into NPM monitoring, including systematic assessment of sanitation, nutrition, disease prevention, access to medical and mental health. Okay, is that unduly broaden the responsibilities of NPM, or does it go without saying? Ms. Paulsen. Ms. Paulsen, yes.
I don't have so much to say about this. I think it's okay, but it's maybe not necessary. I
It's
don't know.
not central, but I think it's in the ballpark. It's something that you don't have to say. Is the NPM, when it does review, does it look at sanitation, nutrition, disease prevention, access to mental health services? So when it goes down and visits a facility, that's just something that they are proactively looking at, or something that if they incidentally find out that there are issues relating to sanitation, nutrition, something that they bring up?
I think all of those are what an NPM would ideally look at, right?
So the next question then is, given the draft in front of us where it says we will undertake preventive monitoring visits and so on to assess custodial policies, procedures, practices, and all other aspects relevant to the treatment and living conditions of persons, do you still feel, and this is directed to Ms. Paulsen, and then maybe the CHR, is there further need to actually detail them to mention systematic assessment of sanitation, nutrition, disease prevention, access to mental health services? For me, my personal opinion is that we don't need to detail because it's sufficiently broad to include those. Because it mentions, custodial policies, procedures, practices, and all other aspects relevant to the treatment and living conditions of PDLs. So that would be sanitation, sanitary conditions, nutrition, disease prevention, access to health services. I think it's included. Do you feel the same way, CHR?
Sure, this is precisely the reason why in the composition of NPM, there is a requirement for an expert on medical field, engineering, so that then we look into situation, they will be able to come up with a recommendation that would include sanitation, medicine, or any program or processes that would require their expertise.
Yes, and Attorney Regalado, is there a provision in the bill that breaks down the composition?
There is, Chair.
There is. Have we tackled that previously?
Not
yet. Not yet.
Malayo pa po ata.
Okay. So I think that will address your concern. Yes, you wish to speak.
Thank you, Mr. Chair. So as for the integration of health promotion in the NPM, perhaps we can include this and specify these further in the IRR.
Okay. Okay, but so you don't feel strongly about your initial recommendation, right? So we can dispense with that.
Yeah.
discard
be,
that for now.
It would be better to be specified further in the IR.
IR. Okay, good. NBI include the requirement of interagency actions, measures undertaken by the guardians. Andito po ba yung NBI? Sir, ang tingin ko po rito, parang IR po to eh.
Good afternoon, Mr.
Opo.
Chair. Good afternoon, everyone. Yes, sir, we do agree. It's not something that we intend to be included in the bill. It's more of a general comment.
Opo. So, Comsec, just note that. So we can, do you, I guess, do we send the minutes or records to the implementing agency so that when they draft the IRR, it has all the insights and concerns raised during the discussion? We can provide the minutes, so that would help. So the minutes will note the observations of the NBI. To the Bucor, the bill must maintain provision required the CHR to establish joint implementation framework. To Colonel Esquivas, ito po yung pinag-usapan natin kanina. But I think we agreed that this will be addressed in the IRR. Yes, sir. Opo.
Just like in the CSAC law, RA 11188, meron po dun, sir, na agency-specific protocols. So, pwede siguro, sir, na kasi we have our separate mandates, sir. Pwede consider, sir, na magkaroon ng agency-specific protocol for AFP, BGMP, Bucor, para po, or one framework
Or
din, pwede rin po, sir.
or maybe we can make a reference when we get to the provision on implementing rules and regulation, a reference to terms of reference or joint framework, blah, blah.
Yes, sir. Pwede
Para
po, sir.
at least, tapos hihimayin na lang pag nagharap-harap sa IRR. Pagka ginawa na po yung IRR, doon ho kayo mag-uusap.
Yes, sir. Pero, sir, kasi kung TOR or framework, this as distinguished from IRR, mas mabigat sa yung IRR kasi may force of law, sir. Kaya, we leave it up to the committee, sir, kung how we proceed.
Bali na sasabihin po ng IRR, that within 90 days or how many days, I don't have the wording in front of me, that the responsible agencies, including blah, will come up with the implementing rules and regulations, including a joint framework. Ganun lang.
Yes, sir.
Di ba? Para makagip lang yun.
Yes, sir.
Okay.
Lisa bit, sir.
So, okay na tayo dito sa Bucor. Nasa APT na po tayo. Delete text relating to coordination with relevant. May we hear from the APT? Ay, wala nga pala dito, no? Sinabi nga pala. Nasaan yung coordination with relevant authorities? It's not in letter B. In information sharing of information of NPM in relation to complaint systemic issues. It's not, this comment does not pertain to letter B. Sorry, it's right there in front of me. To undertake preventive monitoring visits and coordinate with relevant authorities. Instead of delete coordination with relevant authorities and other issues. And place it will make recommendations and enter into dialogue with the authorities. Include the bill, cooperation sharing of information of NPM in relation to. Okay. I'd like to hear comments on this. And I feel that coordinate is sufficiently broad to include making recommendations and enter into dialogue with authorities. What is the purpose? You coordinate everything, including your recommendations. O sa mga dito, sa mga lalo na sa mga abogado. Yung statutory construction. Plain meaning. It says to undertake preventive monitoring visits and coordinate with relevant authorities to examine and assess the custodial policies and all of that you mentioned for a particular purpose. And then it says, yung sa APT sabi, delete coordination and replace with to make recommendations and enter into dialogue with authorities. Parang mas maganda yung coordinate. Because if you're coordinating, it doesn't really prevent you from making recommendations. In fact, if you say make recommendations, it actually precludes other activities that may be deemed coordination. Di ba? Parang it unduly restricts the meaning of coordinate by saying make recommendations and enter into dialogue. Di ba? Parang coordinate is broader, that it would include the latter. Sino mo nag-agree, sino disagree? Attorney Esteponia, tingin mo.
We submit, Your Honor. We agree. Basta lang, Your Honor, hindi siya makonstrue as prior coordination. That runs counter to visits being unannounced.
To undertake preventive monitoring visit and coordinate with others to examine and assess the custodial practice. Oh, yes. Well, that's a good point. But if you read it in the context of the entire bill, it's clear that it's unannounced. So, okay na tayo dyan? Other views? There being none? So, na-address na yun sa APT. Okay. There be no other comments? Written or spoken? We are adopting letter D. Going now to letter C. There are no comments. Examine and review national laws, policies, procedures that relate to the treatment, well-being, and rights of persons deprived of liberty. Pag dyan may nag-comment pa, talagang hindi ko na alam talaga. Pwede kayo mag-comment. I support. Ganun lang yun. So we are adopting letter C. Letter D. Last 2 minutes. To submit to Congress and President's annual NPM report and shall obtain, blah, blah. That is just the NPM report shall include the report to Congress and budget shall be published and disseminated to all stakeholders. Bucor says a parallel submission to custodians must be required. Gusto niyo ba? Lalagay pa yun? Sabi stakeholders eh. That includes the custodial agencies. Tama?
Sir, comment, sir.
Ha?
Comment, sir. Di ba, sir, pag NPM, confidential in nature. So, would this, violate yung confidential nature kung ipapublish?
Ms. Paulson.
No, in fact, the publishing of annual reports is required in OPCAT. So,
and if there are privacy issues concerned, that's the Data Privacy Act will take care of those issues, so that personal information, sensitive information, will be redacted. Other concerns? So there being none, so we are adopting letter D. To refer any factual incident of torture, degrading, blah, blah. It may discover during its visit to appropriate as within places of deprivation of liberty. Amend and clarify that individuals are to be deferred to the stage of investigation. Clarify the case in case of torture to the prosecutor. Itong comment po ng APT, it unduly restricts the interpretation. I've noticed this pattern. It's sufficiently broad. as worded, that the NPM shall refer any factual incident, it may, and then so on, it may discover during its visits to appropriate authorities within places of deprivation of liberty. Within places of deprivation of liberty. Is the concern here, I guess yun ang medyo vague, you know, within places of deprivation of liberty. Okay. Ito po, do you agree that yung reporting requirement that it shall report it to appropriate authorities within places of deprivation of authority is vague or unduly restrictive? Kasi parang it implies that you can only report it to the authorities within the facility. Diba? So, my recommendation is that to the appropriate authorities, ganun na lang. To the appropriate authorities and delete within places of...
Mr. Chair.
Yes, who's that?
AFP, sir.
Okay.
AFP.
Colonel
Sir,
Stevens.
I understand, sir, kasi preventive ang concept ng NPM. Kaya any violation shall be made confidentially between those who manage the detention facility and the NPM team. Kaya within the place of deprivation of liberty. Kasi kung i-report na nila sa appropriate authorities such as the CHR, mawawala na yung mandate ng NPM kasi naging partial na, instead of being impartial, maging partial na sila. And it's the work of the CHR under RA 9745. So yun po, kung gano'n po ang managers ng place of that detention would now be, kumbaga hindi sila confident makipag-deal with the NPM kung ganun po ang mangyayari, sir.
But there's some coordination involved between the NPM and the CHR, right? Can you, Attorney Regalado, explain the dynamic?
Yes, Chair. I agree with the position made earlier by Attorney Skivias. The NPM really is trust building. For the POD to work with them, there should be parang confidentiality muna. So if there's any finding of torture within the place of deprivation of liberty, it should be resolved first by the management, the facility. In the event that no action was made by the POD, that's the time that the report may be submitted to the Commission on Human Rights. But we will the effort first is for the POD and NPM to resolve the issue without involving other authorities externally po.
So the question then is, where do you stand on the proposal of the APT to clarify that individual cases are to be referred to the CHR for investigation, or in the case of torture or serious human rights violations to the prosecutor? Is there a need to state that here? Parang hindi eh.
No, Chair. Otherwise po, baka hindi na magkaroon ng confidence ang ating mga POD to work with the NPM.
Oh, tsaka it's like...
That is actually the difference between the work of the NPM and the CHR po.
And also, this one, the APT opinion relates to individual cases. Di ba? So, parang this is beyond the purview of letter E. This is not what's contemplated by letter E. This is something different. Letter E is apples. APT is oranges. No? Parang magkaiba eh. So, does everyone agree? Okay. Balay says, establish protocols for when NPM findings may inform CHR investigations while preserving NPM neutrality. Again, Meron ho kinatawan yung balay. He left na. But I think that it's along the same lines. So, okay na po to, no? Other observations? So, we will retain the original wording of the draft and discard my initial, suggestion. Letter F, to work where appropriate in cooperation or consultation with any person, whether public or private, in connection with the discharge of any of its functions under this Act and OPCAT. Commence a provision that was done. The United Nations, SPT. SPT. Miss Paulson yan. Sino yung SPT? Rules? Wala. Commence a provision of dialogue between NPM and the Township regarding implementation. Okay. Can we take a break for 15 minutes? I'll be back in no time. Actually, no time is wala. Inconsistent yung sinabi ko. Pero ganoon na lang yun. Balik na lang ako dito.
Yes, sir.
Natawa ako eh.
Letter H,
Guarantees of NPM.
Section 6, letter H po.
Because I believe we revised section guarantees, right? 6 na wala yung 6. At wala dito. 5 to, no? 5. Ito. H. Yes. Did we change section 6? 6? Yung guarantees. Ano yung ginawa natin?
Pinagtapat natin sir yung off-cut provision and then so we will adjust it accordingly.
But this,
To the off-cut.
can we flash the section 6 as revised? We want to see if section 6 as revised has that language that is proposed by UNSPT regarding to the effect that the relevant authority shall be required to examine its recommendations as the NPM and to enter into dialogues with the same to discuss and agree on possible implementation of corresponding reporting measures. Parang wala. Wala, no? Access to all information, access to all places, opportunity to private interviews. E, liberty to choose. The right of contacts with person. Is that the last item, letter F, on the revision? So I believe it would make sense if you want to expand the list, no? The guarantees. To include yung letter H. Teka. So this is what we're doing. We are with respect to section 6, we adopted the new OPCAT, di ba? And then we're revising letter E, right? And then we need to compare it to the list on section 6 to see what other guarantees are not included in the revision, then add it. And then hopefully we include the language that the UNSPT wants to include. So can we just focus on section 6 first? So going line by line. Letter A is access to information. Okay, yan. Letter B, access to all information is captured as well. C, unrestricted access. There's a mention there of access. Yes. And then liberty to conduct private interviews. Is there mention on the right-hand side of interviews? Kasi ayun, private interviews, right? Okay, and then we go to, what about yung choose the places to visit? Meron dyan, yan yung E, right? Liberty for NPM officers and duly authorized personnel to visit all places of deprivation of liberty. I think that is stated there already. Scroll up. Yan, access letter C, right? F, freedom to determine its own rules and procedures, including the programs, its program of visits. Is there any mention there? Wala. Okay, my suggestion is on the right side, you add as G. Hindi. Ang nire-revise natin yung kanan. Ang nire-revise natin yung kanan. Sa dulo, yan, meet with it. Then add letter G. And then adopt the letter G from the other side. Yan, idagdag mo sa kabila. Teka. Now, let's look at the grammatical sense, however, because the introductory text talks about all branches of subdivisions and agencies of the government, yan, shall guarantee the NPM the following. And then let's go to letter G, see if it flows. So that would be, meron bang article dyan, the freedom? Para to be consistent lang. Shall grant the following. Access ganyan, grant the opportunity, grant the liberty, grant the freedom. The. Shall grant it the freedom to determine its own rules. The. Okay? And then you go to H, copy H, but we'll reword it. But we'll make it, rather than word it like this, let's look at yung OPCAT section 22. Can you just copy that first? And then paste it there, and then we'll, as a letter, next letter. I. Okay, make it I. Okay, now, it has to read all branches, so on and so forth, shall guarantee the NPM the. Okay? So, paano natin ayusin yung I? Is there like an obligation of state? Or maybe it's better move to functions of the NPM. Because the way it's worded here, it's an obligation of the state. It's a state mandate. No? So we have to my suggestion is perhaps sa second paragraph na lang yan. Parang all branches go yan. Parang later on you'll say the government shall also parang examine the recommendations of the NPM and enter dialogue with it on possible implementation measures. That's my suggestion. Para hindi tayo, ang hirap i-flip like to fix the wording. So, but in the meantime, hold on So, we'll park I for yung letter I, handali lang. Let's move on. I just want to sweep the other, because if you look at I, of the original draft of section 6, no? Section 6 ba? Says that the relevant authority shall be required to fulfill recommendations of the NPM by implementing the agreed upon measures accordingly. Should the authorities fail to act on recommendation, NPM shall forward its findings to the Department of Justice. The relevant authority shall be immediately filed. Nasa guarantee siya So grant the following. Letter H. Oo nga eh. Nasa H nga siya. It's on section 6. So, but wait. So we will, for section 6, we're keeping, we have inserted determine its own rules and procedures, right? Yeah, and that's letter G. And then we have added H, and we'll add I, we'll add J. Oh, so we're adding HIJ. Yan. H, I, and then J. So, okay, so here's a question now. Is there a need to revise it, yung HIJ, o hindi na? Parang hindi na yata eh. Hindi na, no? Shall guarantee the following. Kaya, I think, yeah, it kind of, in terms of the sentence structure, the fact that it starts with that, it kind of signals that it's from the point of view of the government, you know, as actor or doer. So we will keep that. Sa that the relevant authorities, that the competent, what's the competent, that's from the, like the competent authorities. Or maybe relevant, no? Just to be consistent. Relevant authorities. Relevant na po yun. The authorities concerned or relevant authorities or the state party concerned. Hindi. No, so the state party, that would be hindi. That the relevant authorities, delete of the state party concerned. So that the relevant authorities shall examine the recommendations of the NPM. Let's just use the abbreviation NPM. Yan. And enter dialogue with it on possible implementation measures, okay? That the relevant authorities shall immediately file. Yan, okay na yan. And put an end there before the last enumeration. Before J. Yan. Yeah, that would be the guarantees. Any objection? So we just came up with a more exhaustive list. And at the same time, we address the concern of, in section 5 of UNSPT. So with that, we hit two birds with one stone. We have revised section 6 to make it more exhaustive. At the same time, we address the concern of UNSPT with respect to section 5. So with that, unless there are other comments, I am adopting F as worded. There are no revisions to F. Kasi yung sinabi ni UNSPT, nasagot na rin sa kabila eh, sa guarantees. Okay? Okay, so it's so adopted. Now, on letter F, G, of section 5, publish information relative to its preventive monitoring, blah, blah, blah. The Bucor says the bill must contain important safeguards to protect sensitive information whistleblowers while ensuring transparency in human rights monitoring. Due prudence, high regard for its rules and regulations relative confident informed consent. Confidential. Okay. Any comments? Yung sa Bucor, yun lang po yung sinabi nila. Ang tingin ko naman dito, This relates to public disclosures, rules and regulations relative to having high regard for its rules and regulations relative to confidentiality and informed consent. That the NPM may determine what information. That the NPM may determine what information shall be considered confidential. Okay. Yung sa provided further, the last, towards the end, that the NPM shall not publish or make known any personal sensitive person data related to any person without persons. Okay, that is consistent with the data privacy. So there's nothing wrong with that. So we move back to the first proviso. Provided that the NPM shall have high regard for its rules and regulations relative to confidentiality and informed consent, may determine in what information shall be considered. Para it gives them the authority to say what's confidential or not. Is that consistent with, as I understand, confidentiality is defined by law. But here you're giving the NPM authority to define what is confidential or not. Ms. Paulsen? There's, if you reading letter G, it reads in part that the NPM, having high regard for its rules and regulations relative to confidentiality and informed consent, may determine what information shall be considered confidential. So the concern is confidentiality is actually defined by law. But here, the NPM is given the authority to define what is confidential or not. I wonder where was this modeled from?
Mr. Chair.
Colonel Esquivas.
Yes, sir. I think what the Bucor is referring to here is the executive order on document security classification, on secret, confidential, restricted. So it's covered by, and I don't know if it's an EO or a law. So aside from that, maybe we could also consider whistleblowers when they become state witnesses that may impact on this particular provision, as well as the provisions of the Data Privacy Act.
Yes. I agree. The question is whether this provision, the draft provision, addresses that or factors that in, takes that into consideration, whether it sufficiently safeguards confidential information. Can we hear from Attorney Arabejo?
Mr. Chair, I'd like to point your attention as well to Section 14 on confidentiality. It appears that our draft has a provision on confidentiality. This might be redundant. Maybe we can just refer to that instead and discuss that topic on Section 14. Because it defines...
We'll defer it until Section 14.
Yes, Mr. Chair.
Okay. Section 14 reads, all documentation and information collected by them shall be kept strictly confidential unless the NPM decides otherwise in relation to a particular document, provided that no sensitive information, whether personal or otherwise, shall be published without the express consent of the individual or authority concerned, provided further that this provision shall be in accordance with all existing laws on confidential and security of sensitive personal information and data, such as but not limited to Data Privacy Act of 2012. Parang that seems broad. Itong confidentiality, the definition of confidentiality section under Section 14. So that if with Section 14, parang, I mean, this, what do you call this? Yeah, it has to be read in conjunction with letter G of Section 6, 5, no? Of 5G, so that we don't need to revise 5G. Because even assuming if the concern is that NPM is given authority to formulate rules and regulations relative to confidentiality, right? If it is not aligned with law, then baliwala yun. Diba? It's against law or public policy, right? Tama. So, is there a question? Should we retain it as is? 5G.
Mr. Chair.
Yes,
maybe, sir, in the last part, in the last sentence, may we propose that after the words without that person's best consent and in conjunction with Section 14 of this Act.
Oh, okay. That's a good suggestion. Shall not publish your... okay. The reference to Section 14, let me see. I think... Okay. The only thing is, ang ayoko lang yung dangling modifier. They might feel the reference to Section 14 only relates to the last proviso. When it also applies to the second proviso, so it has to be placed somewhere like near the top. Okay. Provided that, pursuant to Section 14, maybe how about that? So, when circumstances so warrant and with due prudence, provided that, comma, pursuant to Section 14, the NTM, having high regard for its rules and regulations relative to conform consent, may determine the information may be considered confidential, or shall be considered confidential pursuant to, or maybe put it, high regard to its rules and having, may determine what information but shall be considered confidential in accordance with Section 14 or pursuant to Section 14. We could put it there or somewhere after. The first provided that, then insert the NPM, or that's letter A, multiple choice. And then having blah blah may determine that what information shall be considered confidential pursuant to Section 14, that's letter B. Letter C is, provided further shall not publish or make known any information without the present concern, pursuant to Section 14. That's letter C. So A, B, or C. Or D, none of the above. E, all of the above. F, some of the above. So, I'll put Attorney Estiponia on the spot. Multiple choice. Where do you want? Okay. The goal is to make a reference to section. Well, first, do we need to make a reference to Section 14? Okay, answer the question first.
For purposes of clarity,
Yes.
Chair, yes.
Okay. Next question. Where do we insert the reference to Section 14? Yung kanina, there? Sige nga, ilagay mo sa iba. Pursuant to Section 14. And then put it right after considered confidential information. Shall be considered confidential information. Yeah, there. Lagay mo pursuant to Section 14 dyan. Yan. And then, lagay mo rin sa dulo, express consent pursuant to Section 14. Okay.
Mr. Chair,
Where?
what if we delete the clause na provided further. Because that part is already discussed in Section 14.
Ah,
Yes.
so ang choice niya, letter D, none of the above.
Yes. Yes, Chair. Pursuant, provided that pursuant.
Yes, I agree. Due prudence, and tuldo ka na yan, after due prudence. Tama? Because, you don't have to talk about confidentiality here because it's separate. There's a dedicated section for confidentiality. So, if you end it there, with due prudence, period. Yan. Delete yan. Strike out. Yan. Period. Would that work? I think that's good. I think it's a masterpiece. Translated in Latin as magnum opus. Okay na tayo dyan? Okay. Next. To submit independent reports, letter H. Tama ba? Independent reports to the SPT regarding the implementation of Republic Act's obligations under ONCAT and OPCAT. Specific timeline of forwarding recommendations. Would you like to include like deadlines? The NBI suggests a deadline because the deadline, naniniwala yung NBI na, ano sabi nila? Yung a suggestion without a deadline is a, what is that? What do you call a dream or aspiration? But ito, kasi naman ito, these are just, these are like obligations. But the deadlines, you can put that in the IRR. Does everyone agree? Okay. Hearing no objection. Okay, but let's APT has a concern. Delete the paragraph or amend to replace submit with communicate. I wonder why. Hair splitting distinctions. I think you call it a distinction without a difference, or hair splitting distinctions. I find nothing wrong with submit independent reports. Although, there's a reference to the guidelines on NPM's paragraph 29. Do we have that? UNSPT points out guidelines on NPM's paragraph 29. Paragraph 29 reads, the state should publish and widely disseminate the annual reports of the NPM. It should also ensure that it is presented to and discussed in by the National Legislative Assembly or Parliament. The annual reports there should also be transmitted to SPT, which will arrange for its publication on its website. Kung gusto niyo bang dagdagan ng this one, the draft letter H talks about submission of reports to SPT. Honestly, I don't know why it says independent reports. Is there like a... It's stating the obvious, eh. Is there like a bias report? Submit a bias report or non-independent report? Submit, if maybe for the time element, let's go to our paragraph 29. It says annual. Annual. Or maybe we'd say annual. We say annual. Let's go back to H. Submit annual reports. Yan. Annual reports to the SPT regarding the implementation of Republic of the Philippines obligations. Okay. Here's a question. Yung possessive na Republic of the Philippines, is that grammatical or ungrammatical? With an apostrophe. State obligations na lang yan. Okay, this is what I learned. Okay. If the noun ends with the letter S, it doesn't automatically mean that the possessive form is S apostrophe. It only becomes S apostrophe if the noun is plural. Tama ba? Di ba? If the noun is plural, then with an S, S apostrophe. But if the noun is singular, it's S apostrophe S. I-check niyo yan sa grammar. Tama yun. Okay. Editor ako dati, news editor ako nung araw sa college, sa Gaidon. but let's not use that. It's masamang tingnan. Of the state obligations na lang. State obligation. Do we use state here? Ginagamit yung word na state. Of the state obligations. The other workaround is obligations of the Republic of the Philippines. Then you avoid the apostrophe problem. But, ano yung say, A or B? Di, ayoko na ganun. State obligation. Under the UNCAT and OPCAT. Okay? Hold on, let me see. But, Ms. Paulson.
On the issue of independent reports, I think it's good to have independent there because it's as opposed to state reports.
Oh, I
that would
see.
be submitted.
I see.
Yeah.
Okay, I see. So I take it back. Please reinsert independent. And also, let's look at Article 22 again. Because there are other... So, these are the obligations of the NPM. So look at Article 29. The first part is an obligation of the state, does not apply here. The second part is an obligation of the state, does not apply here. The third part is an obligation of the state, but it references the obligation of NPM to submit annual reports. Okay, so let's go back to the draft. Okay, that's good. Do you agree? Okay. At this particular point, do you feel that that's a masterpiece? Huh? Okay, so we are adopting H unless I hear otherwise. No further comments? Letter H as adopted as revised is adopted. Moving now to I. Promote public awareness through the publication and dissemination of information and education materials on its work as the NPM. Fine says, is Fine present? Ms. Bello present, says, paragraphs I and J, amend to include active collaboration with civil society in the implementation. Balay says, conduct public awareness campaigns to inform detaining staff in communities about the NPM's role and mandate. Ako tingin ko po, implementing na to eh. It really is implementing na. When you promote public awareness, you need to expound on your role. What are you doing, right? So you have to come up with specific programs, I include collaboration with civil society to train and capacitate the relevant authorities charged with the treatment of persons deprived of liberty and management of prison. And then FINE says, in collaboration with civil society in the implementation. Do we need to say that, or is that implementing rules?
We concur that it could be included in the IRR na lang po.
IRR na lang? Kasi NPM cannot do it alone eh. They know that eh. So in implementing rules, they're gonna collab with civil society. Attorney Regalado.
Chair, we have also Articles 15 and 18, Sections 15 and 18. For collaboration with government agencies and CSOs as well as promotions po.
Nice input. Salamat po. Naisip na ni Atty. Regalado yung pag-uusapan niya at nailagay na nila sa draft. Okay. So with that, I think we can adopt letter 5I and 5I. Moving now to 5J. Train and capacitate the relevant authorities charged with the treatment of personals, PDLs, and the management of places deprivation of liberty. Bucor says must provide capacity building programs for custodial staff. That's, I think, implementing. Implementing po yan, IRR. Require pilot NPM operation in selected facilities before national implementation to refine procedures. That's implementing. Develop capacity building programs for NPM personnel. That's implementing. Do you agree po? Lahat po yan implementing rules. It's really important to share the minutes of this meeting to the agencies drafting the IRR. Para lahat po ng, in this format, maganda yung ginawa ni COMSEC na kitang-kita yung mga, put a note, please share. Bucor, share with wherever we say it's for implementing rules, let's put a note there, share with implementing agencies. So with that, unless I hear otherwise, Section 5J is adopted. Moving now to Section 5K. To ensure the protection and uphold the principles of non-refoulement for persons deprived of liberty in their performance of its mandate in coordination with relevant agencies. There are no comments here. I take that to mean that we can proceed to adopt 5K. And it is so adopted. Moving now to L, to establish its own rules and procedures in carrying out its mandate and to create line agencies necessary and relevant for the execution of its functions. UP IHR says such power must be exclusively exercised by the NPM to ensure operational autonomy. Agreed. We talked about it earlier. This further distinguishes the NPM approach to visits as pro-tac non-adversarial from the CHR's investigative approach, which is reactive. Tama. So, now, creation of line offices necessary and relevant for the execution of its functions. This goes to implementability. Implementability is something that well, is it needed? Perhaps. Question, can it be done? May CHR siguro, no? I'd like to hear from CHR. Yung sa una, creating rules and procedures, that's, it's a frugal activity. There are no expenses involved. Okay, so it's a desk job. Dali lang yan. How about, but to create line offices, okay? Can we afford that given the allocation for the MPM? Attorney Regalado.
Chair, I think this should be included, considering that the NPM should be given the the authority or the power to create its offices, especially if they, especially in the regions, if they are expected to deliver their mandate po.
Although, Attorney Regalado, in the meantime, they will use a CHR structure, no?
Yes, sir, but as we all know, the structure of the CHR is quite
Limited. Only 17?
17 regional offices, and and we don't have presence po sa baba, and even in the regions po, and in the provinces po.
Sige, so I guess it has the, within the, if it's within the budget, no, they would do that. Any objection? There be no objection. Section L is adopted. Letter L is adopted. So guarantees, we have addressed. We have addressed all of that. So now we leapfrog to Section 7. Composition of the NPM. Konti na lang, huwag kayong bibitiw. Kapit-bisig lang. The NPM, which shall be an independent and collegial body, shall be composed of the chairperson of CHR or his or her representative commissioner, sitting as ex officio member, and 10 other members with the following qualifications, okay? Wow. There are A, B, C, D, A, B, C, and there's a criteria for appointment. Okay? AFP says, the CHR Commissioner should not be part of membership of the NPM, instead appoint a lawyer who is an expert on human rights. I think you're, because of the conflict, no? Independence. Okay, maybe hear from the CHR. Attorney Regalado.
Yes, Chair, that the inclusion of the chairperson or his or her representative is included by the very nature that the NPM is an attached agency po.
Colonel Esquivas.
Yes, sir. Kaya din, sir, yung concern namin na it's an attached agency for budgetary purposes. Kasi nga yung impartiality, sir, and yung nga, sir, the CHR implements RA 9745 and RA 10353, the anti-torture law and anti-enforced appearance law. If it will, the chair is part of the NPM, it's as if the CHR is wearing two hats. No? One is preventive and the other is, sir, for purpose of prosecution and filing of cases. Kaya maganda, sir, na totally, sir, na wala nang, and it's not required naman, sir, as we see in the OPCAT, na kailangan yung NHRI is part of the NPM.
Can we hear from Ms. Paulsen, you think? Ms. Paulsen, would you like to comment on that? Any insights on wearing two hats and possible conflict if you have the CHR chair as chairperson?
You have some scope for, deciding yourself on this one. I'm afraid that's not a very clear answer, but there are a number of countries where indeed the NHRI as a whole is appointed as the national preventive mechanism, which is even more mixed than here. Right here, you have some happy balance, and in those cases, certainly the ombudsman would be, or ombudsman or CHR chair, whatever you call it, would also serve as the NPM in the NPM. So, for example, I think New Zealand, Sweden, some of these places, the institutions are the same. But if you have it as an attached, I mean, I think although the SPT allows for both, the preference is to have them as separate as possible. Here, I think we are striking a balance. So it's a little bit up to the legislators, I'm afraid.
Okay, let's look at the DOH to see if the DOH has the same concern, designate CHR on authorized commissioner as MPM chair to ensure institutional leadership accountability. So DOH is actually in favor of having the CHR as chair. No, but it's as ex officio member. It's not saying that it will chair it. The chairperson of the Commission on Human Rights or a designated commissioner will be ex officio member. So it's diluted. They're not like, they don't have a central leadership role in the NPM. No? They're only one member. When you look at it, that's sensible. It's just mere membership. And this concerns, torture, so that's within the mandate of the CHR. So they're concerned agency. The DOH is more aggressive. They want the CHR chair or a commissioner, CHR commissioner, to be the NPM chair. That's where it gets iffy. No? But DOJ must include provision on executive director, which is being referred to in section 12C. Section 12C. Nag-iba na. So let's do a search for executive director in the body. Let's see. Mayroong executive director. Okay. So the question, well, first, is an executive director a member of the NPM? No, I don't think so, no? Pagka executive director, they're not members, eh. Right? Parang ano lang yan, parang secretariat, right? So if the executive director, because the DOJ is proposing that there should be a provision on executive director, right? But then, if you include it in Section 7, then you are recognizing that the executive director is a member of the NPM, because this talks about composition of the NPM, correct? Tama? So that we don't need to include, we don't have to reference the executive director here. Kasi they're not a member of the NPM, eh. Right? Okay. So that takes care of the DOJ's concern. The DOH concern, Department of Health is here. You heard the concerns of Colonel Esquivas regarding wearing two hats and having those two hats at the helm of the NPM. It's a very iffy situation, right? So do you submit that maybe mere membership is good?
As for the DOH, actually we concur that, as stated earlier, that the head of the NPM would be the chair of the CHR, because this is because the NPM would be an attached agency to the CHR, and that is why we're in favor of it.
Actually, what Attorney Regalado said is that the CHR is a member of the NPM because it's an attached agency, but she's not necessarily saying that the CHR chair should be the chair of the NPM. Magkaiba po yun. Ito mere membership lang. Because the problem is, you are courting conflict of interest. If you have at the helm a person na unless they have split personality o bipolar sila, no? One time they're like, oh, CHR mode, and other mode is like, no, I'm NPM no mode. So, according to the CHR, because the NPM is an attached agency of the CHR, they should be a member. They're not necessarily batting for chairmanship. You're batting for chairmanship, but the problem there is you're courting instances of where they are torn.
So, actually, on our end, we just see that having the CHR chairperson as the head of the NPM would ensure clear institutional leadership and accountability. Given that the chair of the CHR would be the authority on human rights. So,
I think as a matter of policy, given the we don't want the overlaps and conflicts arising, given the similar nature of the responsibilities of the CHR and the NPM, that, you know, it's, and also as Ms. Paulson advised earlier, it's best to make the CHR mere member na lang. That will reinforce the independence or semblance of independence of the NPM. Hindi pa natatapos yun eh. Pero if the CHR has, the chairman has a dominating influence, dominant personality. Pero si Attorney Richard, hindi naman ganun, you know, manumanay. Yeah. Manumanay. Safe answer. So that was, then the APT says, based on experience with other NPMs, APT says, it's on the board, based on experience with other NPMs, functioning is more efficient with fewer numbers, working full-time with longer appointments of 5 to 7 years. NPM must be supported with professional permanent secretariat. That's all admin. It's admin. We don't need to spell it out here. It has administrative independence. It can do whatever it wants with the budget that it's given. Clarified in the different roles and responsibilities of those that make the NPM decision-making role, Chair, Section 7-8 are somewhat repetitive, which may be better included in the terms of reference of an appointment does not exceed to be. Too much legal law may limit the number of qualified candidates. Bill does not state whether members will be full-time or part-time. There's no provision sets out the policy grounds and processes for the removal of members. Parang ano yan eh, IRR. Shall be composed of the following. Okay, ex-official member is the CHR, 10 other members with the following qualifications. UPIHR says, incorporate grounds for dismissal, appeals procedure, granting immunities during exercise of mandates in connection with the NPM's work. Okay. Granting immunities during the exercise of their mandates in connection with NPM's work. Is it something, Ms. Paulson, that is you find in other models, that the NPM has immunity during the exercise of their mandates?
To be honest, I'm not sure. I would have to look into that. But I was wondering what's the case for the CHR, because that must be a parallel kind of...
Parallel conduct, yeah. CHR, in the discharge of your functions, are you immune? The answer is no. Oh, pero
not exactly immunity.
not immunity.
From criminal.
Oh. Diba hindi? There's a presumption of regularity in the charge of functions. If you exceed your authority, right, then you would be subject to suit, abuse of power, right? is one. Attorney Regalado.
Yes, Chair. Chair, we may refer to Section 16. Protection from criminal liability. I think they should cover the.
I agree. Section 16 is actually broadly worded. Would you like to leapfrog at this point or no? To Section 16. Oh, well, since I'm gonna read it, might as well read this. Let me see if there are concerns raised for Section 16. Okay, with respect to, just to be more efficient, because there's a mention of immunity, let's go to Section 16. There are only two comments on Section 16, one from the AFP. The section must be reviewed thoroughly as good faith should not be used to avoid liability for crimes or offenses committed. Okay. To include provision that funding support be made to NPM members who will be made respondents or accused of cases filed against them in relation to or connected with their work and function. UNSPT commends a provision consistent with the OPCAT Articles 21 and 25. Can we look at OPCAT 21, 25? Yeah,
Sure.
Delgado.
Shall I read?
21. No authority, okay, which is aligned with 16A. If you look at 16A, that's the same. Okay, hold it. I'll read 16A while you're reading Article 21. Okay? You see if it's the same. Okay? 16A of the draft reads, no authority or official shall order, apply, permit, or tolerate any sanction against any person or organization for having communicated to the NPM. Okay? Including its officers and staff, any information, and no such person or organization shall be otherwise prejudiced in any way. It's the same. Okay, so 16A is okay because it's consistent, right? Okay tayo sa 16A. Now, going to B, look at 25, sorry. Bakit ganon? 25. 25. The expenditure incurred, yes. 35. Let's look at 35. Thank you, Ms. Paulsen. Privileges and immunities. Where is that statement? As are necessary for the independent exercise of the functions, members of the subcommittee shall be accorded the privileges and immunities specified in Section 22 of the Convention on the Privilege and Immunities of the United Nations of February 13, 1946, subject to the provisions of Section 23 of that convention. I love the jump lines.
Yeah.
So the question is whether Section 16 incorporates those provisions mentioned in Article 35. Section 16, so we've already addressed 16A. 16B is relevant authority shall take effective steps to prevent and promptly respond to any sanction or act of reprisal stemming from communications to or cooperation by other persons or organizations with the NPM. Letter C, no criminal, administrative, or disciplinary sanction shall be taken against any person or organization for having communicated in good faith any information to the NPM, including its officers and staff. D, anything done in good faith and pursuant to the functions and powers conferred upon the NPM on this act or in respect to any publication by or under the authority of the NPM of any report, proceeding, or any other manner on this act shall not be a ground for action, suit, or a legal proceeding against other member of the NPM is officers. Last, these are harassment cases. Any legal action filed to harass. Ms. Paulson, are you familiar with the OPCAT 35? Sorry.
Exercise of their functions.
Yes. So that's the excerpt that we would like to borrow from the. Okay.
Very
With-
much appreciated.
Ms. Paulson has given her permission, so we can borrow that language. Did you get that? So if you flash that, the OPCAT, yeah. The first sentence you will refine it. And then we have to, so 16A is okay. We have adopted that. Letter D of section 16. Yun po. Yan ang privileges. Yun po. Yan ang privileges and immunities nila. No authority or official shall apply, permit, or tolerate any sanction against the person. The authority shall take effective steps to prevent or promptly respond to any sanction or reprisal. Letter C. No criminal and administrative disciplinary sanction shall be taken against any person. And then anything done in good faith pursuant to the powers conferred on NPM under this Act shall not be a ground for action. And then any legal action filed to harassment be immediately dismissed with prejudice, and of course may award damages to third officials. Those are the privileges and immunities. Is there anything else? I cannot think of any. Ano nakalagay doon, Colonel Esquivas?
Information, yung letters A to L.
Okay. Can you look at letter F, yun nandyan sa right side? Just scroll down a bit. Yeah. Because the thrust of this was we got this from Article 35 of OPCAT. Can I see Article 35 of OPCAT? Of the NPM. So that they can, diba yun ang, and with the protection from criminal liability and other sanctions and reprisals, they can do their job in Section 16. Ano sabi? Yeah. Well, if you look at Section 16 of the draft, protection from criminal liability, other sanctions and reprisals. First, is there a legal basis for that? Absolutely. You're trying to do your job. You're trying to do your job, and you can perform your job because of these of sanctions, fear of sanctions, that you will be sued or be subject to frivolous lawsuit, or so you can't do your job. So this is saying that you have nothing to fear. See, so that's letter A. So maybe why don't we... Now, AFP says the section must be reviewed thoroughly, as good faith should not be used to avoid liability for crimes or offenses committed. Wait a minute. Good faith should not be used to avoid liability for crimes or offenses committed by the NPM? That's Good faith is a defense.
Yes, sir. Ang inaano namin, sir, baka maabuso, sir, na sabihin good faith. Dahil it's a defense. Pero actually, sir, ginagamit yun to file cases, sir, without basis. Yun, sir, ang iniisip namin.
No, so the scenario there that somebody would sue the NPM, right? Ito yung context ito eh.
Ano, sir, it's the NPM that will sue yung members ng NPM or staff na sir. Kasi sir, kaya nga sir, yung next namin, to give funding support naman for the NPM members who will be subject of cases.
But if you look at letter D, anything done in good faith and pursuant to the functions and powers conferred upon the NPM. So who is invoking in good faith there? It's the NPM. Yes. Right? So if they're sued, right, their defense would be good faith.
Yes, sir.
And you're saying here that good faith should not be used to avoid liability for crimes or offenses committed.
Ang sir, to be examined thoroughly, sir, siguro sa IRR na merong parameters sa what is considered as good faith.
Hindi po.
Yes, sir.
Ano ho yan eh? At sa, that goes to the mental state eh. If it's unintentional and you don't have malice, di ba? I was confused by you said good faith should not be used to avoid liability for crimes and offenses committed. Okay. Okay. Here, good faith is this contemplates an action or activity, direct or conduct directed against the NPM for merely performing its functions and duties. Right? Tama ba? That is my understanding. So that's why it's talking about privileges and immunities, right? And nakikita niyo from A, any sanction against a person or organization having communicated to the NPM and people who have and allies of the NPM, people who help the NPM, prevent, respond, in sanction, act, price stemming from communications or to or cooperation of other persons or organizations with the NPM. Okay. Criminal sanction against any person or organization for having communicated with the NPM. Okay. Anything done in good faith and pursuant to the functions and powers conferred upon others. So here in D, diba? It's with the NPM. I guess my question for the FP, who is being sued here? When you say good faith should not be used to avoid liability for crimes or offenses committed, who is being sued? Because Section 16 is from the point of view of NPM and individuals and entities assisting the NPM. So, sino madidemanda ron? Di ba? NPM and individuals and entities assisting the NPM. So, pag sila dinemanda, whatever, because they exceeded their powers, they abused their authority, isn't the defense good faith? And yet you're proposing that should not be used to avoid liability. Attorney Arabejo.
Yes, if I may add, if I may clarify, the NPM is a government agency, correct? So they enjoy a presumption of regularity in the performance of their tasks. Now, if the NPM commits if any of the NPM members commit a crime outside their functions, they really cannot invoke good faith because they committed a crime. They will be sued criminally. But I suppose what's contemplated here is because coming from the experience of CSOs, because we're not government, so we don't enjoy the presumption of regularity.
Yes.
There are times when we conduct investigations, documentations, and then there are cases filed against us to harass us, such as trespassing, for example. So I think this is just a added layer of security that if the NPM conducts visits, there will be no trespassing cases filed against them. And if there is, it will be dismissed on that ground, as stated in 16E. So I just wanted to clarify that. But certainly, if the NPM commits a crime, they cannot invoke good faith. They cannot invoke presumption of regularity. So I agree with you, sir, na they really should not, if they commit a crime, they should not invoke good faith. But, by default, they enjoy a presumption of regularity.
If NPM commits a crime, they cannot invoke good faith.
Such as murder, Mr. Chair, for example.
No.
Because it's outside their,
No.
in their personal capacity.
If you invoke good faith, you're saying an element of the crime is missing. Intent is missing. Yes, criminal intent is missing. So therefore, it's good. So good faith is the defense. Oh, pumatay ka. Diba? You can invoke good faith. Di ko naman sinasadya eh.
Self-defense. Well,
Di ko sinasadya. Not necessarily. You know, pumatay ka ibang tao. Oh, di ko naman sinasadya.
in any case, Mr. Chair,
Good faith is a defense because it eliminates the malice or the mens rea. Tama ba? Sabi mga abogado.
Sir, ang is sir, hypothetically, sir. For example, a member of the NPM submits a report pero without legal basis or and later on ginamit yun ng CHR to file the case against a particular individual, and now this individual wants to get back at that particular NPM member because of probably for negligence or so ang inano ko, sir, na yung good faith na i-invoke na yon, at least ma-review thoroughly. Yun ang sa akin. Understanding, sir, na merong it's a defense and well, sir, kaya nga converse, sir, inaano ko rin na kung sila naman kasuhan, yung member ng NPM, maganda kung meron din silang funding support. Kasi they will face the case on their own. So maganda, sir, kung merong provision na they will be provided by lawyers, by the government, and expenses to face the case, sir.
That's a good suggestion, yung pro bono legal assistance. But going back, kasi if it's an intentional crime, then good faith is a defense because you eliminate the intent. But if in your example, it seems that was carelessness. What if it's negligence? Negligence, kinulang, or incompetence, and then that person is sued. You cannot. Good faith would not be a defense. Diba? But going back, let me see. Let's see if it really is what they call this implicated in the section. No, we'll go subpart by subpart. In 3A, no authority shall order, permit any sanction against person or organization for having communicated to the NPM. No such person shall always be prejudiced in any other way. Okay. Ito yung mga tumutulong. Those are aiding the NPM. They should not be. There's no reprisal. There's nothing wrong with 16A, correct? Okay tayo sa 16A. 16B. The relevant authority shall take effective steps to prevent and respond to any sanction or act of reprisal stemming from communications to or cooperation by other persons. Okay lang yan. Okay? Nothing wrong with that. C. No criminal, administrative, and disciplinary sanction shall be taken against any person or organization for having communicated in good faith any information to the NPM, including its officers and staff. Ito, hindi ko lang bakit may good faith dyan. No criminal, administrative, or disciplinary sanction shall be taken against any person or organization for having communicated in good faith any information to the NPM. Meron kang, you passed on, you passed on information to the NPM. And then you are subject to criminal suit. If you did it in good faith, this is saying, then you won't incur liability right? If you did it in good faith. What if you take out in good faith for having communicated any information to the NPM? It's more aggressive, right? Is this unless I'm thinking in the context of, data privacy, no? May sinabi ka sa NPM, may you breach data privacy, right? So the question is, if you did it in good faith, here, it's a defense. Because if sabi dito if you communicate in good faith any information, no criminal sanction. Right?
False information, sir.
Huh?
False information that given in good faith.
False information giving in good faith. Any information that's false or not. Any information to the NPM, including his in good faith. In data privacy law, his intention, a breach is could be committed by negligence. So you would incur criminal liability for that in data privacy, right? So good faith is not a defense under data privacy law. Where do you stand on 16C? DOJ, can we maybe hear from the DOJ?
Mr. Chair, if we are going to look at Article 21 of the OPCAT, it actually states there that no authority or official shall order, apply, permit, or tolerate any sanction, etc., whether true or false. And no such person or organization shall be otherwise prejudiced in any way. So I think this could be a starting point on this provision.
Yeah, we adopted 16A, which is consistent with that language. No authority, as you read. However, so 16A, we approve that. B, we adopted as well. We're now on C.
Yes,
16C.
Mr. Chair. I was trying to emphasize that it states here whether true or false.
Yes, I understand, but the question is in good faith. In good faith, what is the role of good faith in section 16C? Oh, I see. I see. This is saying, because if you deliberately communicate false information, right, then you will be liable, right? So your defense is good faith. I didn't know it was false.
Yeah.
Correct?
Yes, Mr. Chair. In the
So-
OPCAT, even if it's false, no liability would be attached. If
Can you read the wording one more time?
tama ba yung interpretation?
21.
So under the OPCAT, even if what you have communicated is false,
What is the wording? Can you read it verbatim?
no authority or official shall order, apply, permit, or tolerate any sanction against any person or organization for having communicated to the NPM any information, whether true or false, and no such person or organization shall be otherwise prejudiced in any way.
Okay, in relation to C, to 16C, no criminal administrative sanction shall be taken against any person or organization for having communicated in good faith any information to the NPM, including its officers. So that, if you communicated something in bad faith to the NPM, you would be liable. In what you read, whether true or false, they are protected.
Yes, whether true or false.
Tama ba? Inconsistent. Inconsistent. What makes sense? Ms. Paulsen.
For me, I read this as consistent with Article 21. It's not about whether it's true or false, it's whether the provider of information believes it to be true or false. So, for example, if you give information in bad faith, you might say, I don't know, you give false information to the NPM and then the NPM publishes it and it's discredited, for example. If your motivation is to discredit the NPM, because and that's why you were giving it, that would be an example of bad faith.
But for me, the bad faith is knowledge of falsity. If you know it to be false and you shared it, that's bad faith.
Yes.
If you didn't know it was false, right? That's good faith.
Still good faith.
So, in the use of the word true or false, no authority shall order, permit, or authority and sanction against any person or organization for having communicated to the NPM any information, true or false, and no such person shall be or otherwise prejudiced in any way, because in the OPCAT, Article 21, it seems like a blanket immunity. It's a blanket immunity. It says whether true or false. It's not talking about whether you knew about it or not. Whether you knew the falsity or not. It's just saying whether it's true or false, you should not be prejudiced in any way. That's what it's saying. But what Section 16C of the draft is saying, no criminal sanction shall be taken against any person for having communicated in good faith any information. So it's inconsistent. 16A is talking about whether true or false. Whether true or false, we will not be prejudiced. Here, Section 16C is saying, you will be prejudiced. Section 16C is only saying, you're only immune if you communicated in good faith any information. So it could be false, but if you didn't know it was false, you're protected. Section 16A is saying whether you knew it or not, because truth or falsity is immaterial for Section 16A. You're still protected. Inconsistent siya. Do you agree? Tama? Tama? Kasi pag tinignan niyo yung 16A, but maybe that is the reason, that's the reason why in 16A of the draft, we eliminated true or false. Maybe that's the reason why we eliminated true or false in the draft 16A. Any information and no such person or organization shall be likely to be prejudiced. Okay, so here's a policy question. Should we make good faith a defense? Because it could be that if you look at 16A, it protects people who are sharing information with the NPM. Okay? If you talk about maybe Article 21 is deliberate in its language in saying whether true or false because you want to encourage people to share information. Right? That's one policy. But if you want to say, but they have to be responsible, right? How will they be responsible? They should only share information that they believe to be true, which is also reasonable, no? We want that. Then we should have good faith. Having communicated to the NPM inclusive officers in good faith any information. Attorney Estiponia, Do you agree there's inconsistency in 16A and 16C? 16C of the draft.
There's a little bit of inconsistency because letter C assumes that the person reporting or the person communicating with the NPM does so in good faith.
So that good faith is a defense,
Yes.
right?
Sa
In
A,
C-
walang
not,
assumption.
there's no mention of good faith.
Yes.
So the policy question is should we make good faith a defense to avail of the immunities provided by this bill, in particular Section 16? Is good faith a defense?
If in keeping with OPCAT chair, then
No, OPCAT is
whether true or false.
Whether
let's
true or
say,
false,
If OPCAT encourages a blanket immunity, then putting good faith in 16C would run counter to OPCAT.
Ay, section na. Hindi natin nadali. Huh? Third week? Are you... That's one, and also as well as the conduct of the NPM officers, whether they can invoke good faith. That's one thing we need to address. And we need to address us because we need to be OPCAT compliant, right? So if good faith is a defense there, in other words, the sharing information to the NPM and the conduct of the NPM officers has to be in good faith, then we have to revise the language, insert and recognize good faith as essential to avail of the immunity. Yun lang. And then sa committee secretary, we have to take note of where we are. We leapfrog to section 16 from section tumalon tayo section 7. Okay? So we go back to section 7 and then siguro we resume section 16, go back to 7, and then go forward from there. We'll adjourn tomorrow. We're resuming session when? July
For the sa SANA po.
20. But we can have meetings. Third week of June. The committee. Why third week of June? Why not next week? Huh? 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 Huh?
Para sabay-sabay, sir, kasi we'll have also another PWG in another subcom. So para isang lang.
O sige, with the committee secretary will inform you of when the next meeting is. Ako, I'm available even on weekends. You know? Oh. Pampapogi lang yun, nasa record eh. Doon tayo sa Las Casas. Hindi, loko lang. Sige, sabi niya. No, so we'll be informed, but I think we're making good progress, you know. And hopefully before the resumption of Congress in SONA na tapos na to, I really want to close out. Kailangan ko ng closure dito. So thank you for your participation, active participation until the next committee meeting. This is Attorney Tony.